come for a while. I might want to make them now because we're not terribly good about predicting exactly when an item down our agenda ways is actually we're going to get to it. But that's your choice again. With one caveat, it's now or later, not now and later. There's no double dipping. We will attempt to call on commenters in order that they appear in the Zoom window and also on the sign-in sheet that we have for comments. So if you're wishing to make comments, do you have the sign-in sheet?
And do we speak? I'm sorry to interrupt. Can we speak here or do we have to approach to speak?
Are you asking where you're going to sit to make your comment?
Yes.
Okay, we have this little table here for you. I'm not sure the mic will pick you up otherwise. So to facilitate hearing as many members as the public as possible, we encourage you not to repeat points that others have made before you. And to allow us time to conduct the business that is on our agenda today, we're going to limit public comments to 2 minutes per person and a total of 25 minutes. We'll know on Zoom that you want to comment if you use the raise hand function. And that's if you're using the video Zoom interface, that is kind of in the bottom middle of your screen. You'll see a raise hand button. Click on that. If you're just calling in on the telephone, you would press the star key on your keypad and then the number 9. And that'll indicate that you want to make any public comment. So we're going to let the coordinator, that's Ms. McFarland, call on members of the public to make comments. She will keep track of time and call out when you have 30 seconds left, in which case we ask you to wrap up your comments. So I don't think I have to ask if anyone wants to make a public comment. Ms. McFarland, go ahead and call the first person.
I think we're going to start with the online public comments. So our first public comment is going to be from Benjamin Stone. You have the mic.
Yes, thank you. I'm commenting regarding the rules revision on the agenda for the testing accommodations. I specifically object to the proposal for the procedural changes that need a rules change floated by staff. Those were not the things that were circulated for the testing accommodation forums and have no bearing on the comments that we heard there and made there. All of the changes proposed are adverse to disabled applicants and solely to benefit the workload of staff. Some of them were rejected by this committee previously in 2021. Others are even worse. I sent written comment with detailed rule by rule objections, but the current proposal wouldn't require staff to even make an initial decision by the next exam cycle if a repeater wanted to apply after the previous exam they last applied for accommodations for expanded accommodations, or first timer didn't.
You have 30 seconds remaining.
Thank you. Apply several months early. I encourage the committee to make rules changes, but not these ones. I have sent a draft for years of what they should be instead, and I encourage you to circulate that for public comment based on having the opportunity on the agenda, so it doesn't wait more exam cycles to
I'm sorry, but
happen.
your time is up.
Thank you.
Comment is from Claudia.
Hi, this is Claudia Center. I'm the Legal Director of Disability Rights Education and Defense Fund. I've been working on disability rights, including access to the profession, for more than 25 years. I was involved in the DFEH versus LSAT consent decree. I've represented many individuals on the LSAT exam before the new rules went into effect, and bar takers. When I describe the bar exam situation to people, I say that it's like the LSAT before the consent decree, and if anything, it's gotten worse in recent years and not better. I've looked at the documents that are being submitted for public comment, and I note that they reference the LSAT consent decree and the DOJ guidance, but do not track. The automatic grants in the main framework do not allow for automatic grants for double time. They do not allow for automatic grants for, they exclude prior grants more than 5 years earlier, which is going to exclude so many people. It does not include grants on the baby bar or the MPRE as a basis for automatic grants. There's no reference to the best insure standard or to the weight to be given to a treating professional. The way that LSAT changed and allowed the pipeline to be open is three things. And this was through the consent decree, the best practices report, and a huge piece of
30
litigation.
seconds remaining.
A huge piece of litigation that I'm hoping we can avoid with the state bar is that there is a change in policies, the formal policies on the ground, change in the procedures, and change in personnel. This didn't work until there were new consultants and new leadership. It all worked once Joan Van Tol left, and there were new consultants that worked on the testing accommodations. That's what needs to happen here, those three pieces.
Next public comment is from Arita.
Good morning. I have a general comment. I'm attending by Zoom. I would like you to turn on the captioning for the Zoom callers, please.
Thank you for the comment. Our next public comment is from Charlene.
Hi, thank you. First of all, I'm a former elected official. I have been appointed on numerous committees from local and county level, and I encourage all of you decision makers, talk to somebody who has had testing accommodations with the California bar exam and find out how truly difficult it is. Every time I've applied for accommodations in the last 3 years, even though I already had approved accommodations, they were wrongly, by error of staff, denied. And I had to go to the top of the California State Bar to have it corrected. There needs to be an appeal process for exam applicants other than the Supreme Court if it's beyond the staff. The staff makes numerous mistakes. Please do not rubber stamp what the staff's recommendations are. Repeat test takers with testing accommodations approved by the California Bar should be allowed to take their exam again with the same accommodations if there's no changes, as long as they sign a declaration stating that there have been no changes in their learning disabilities or physical disabilities. I'm 53 years old. Learning disabilities do not go away. If you want to do a two-tiered system, do something for younger people that are in their early 20s and something for older exam applicants. I went to law school in my 40s with 2 teenage boys. It was an accomplishment. Do not penalize people for going to law school with testing accommodations and you have no intent of providing accommodations to them for the bar exam. You are not being
30 seconds.
You are not being inclusive. You are being uninclusive. In order to create additional transparency, you need to allow more than 2 or 3 minutes for public comment. There's something in California called the Sunshine Law. I highly encourage you to adopt that. I served on committees that encourage communication and feedback. The California State Bar staff do not communicate with the exam applicants. They will just say your application is incomplete without calling you and letting you
I'm
know.
sorry, but your time is up.
document. You guys completely suck. I'm sorry.
Our next public.
Somebody's laptop is logged in and have their mics open.
Somebody on Zoom.
Yeah, very I use this mic over here, so we can proceed. Hopefully it'll serve well.
Our next public comment is from Peter.
Hello, my name is Peter Maduro. I am a clinical psychologist here in Southern California. My clinical practice includes disabled folk, some of whom have been students and applicants to take the bar successfully and unsuccessfully. I also have a prior career in the law. I'm admitted in good standing in New York, Massachusetts, and California. So I have a lot of experience in taking bar exams, including twice in California, having been unsuccessful in the first attempt. So I know firsthand what is involved in getting through a bar exam. And I also work extensively with emotional trauma. And I think my comment is really a higher level one. What I'd advocate for is to take I have an eye, by the way, on the proposed rule changes 4.84, 85, and 90. And what I'm advocating for is that you guys take very seriously the profound impact of the kinds of rules that you put in place, and that the preparation alone, we all know, can be challenging, but becoming
30 seconds.
unsuccessful by virtue of procedures and rule and time frame can be really deeply traumatizing. So for example, with 8.4, I'd advocate to ensure collaboration. Try not to extend timetables that make the process more difficult. With 8.5, don't include non-substantive language that just opens up more opportunities for inadvertent trouble in preparing and
I'm sorry, but your time is up.
Okay, thank you very much.
Our next public comment is from Christina.
Hello, good morning. My name is Christina Gonzalez. I'm a 2012 graduate of People's College of Law here in Los Angeles. I'm a member in good standing of the California Bar and have dedicated my law practice to public interest advocacy, specifically housing rights and eviction defense. I'm here today to express my support of People's College of Law and advise the committee to recommend that People's College of Law be placed on probation rather than be stripped of its degree granting authority. PCL must maintain its degree granting authority to continue producing successful people's lawyers and legal experts, such as myself, in the state of California, as it has for over 50 years. As you probably know, People's College of Law has offered a community-based, low-cost Juris Doctor program to empower underrepresented working class communities to enter the legal field and become people's lawyers. Our alumni network includes successful attorneys in the fields of civil litigation, criminal defense, immigration representation, housing rights, and more. Also including public defenders, nonprofit legal aid attorneys, local and state elected officials, and esteemed community-based leaders. The student body is comprised of working class students, students of color, and advocates from respected organizations across Los Angeles County. It's important to note that People's College of Law does understand the infrastructure and capacity building needs of the school. PCL is always working hard. Thank you. PCL is always working hard consistently to make necessary improvements to advance the sustainability of the institution. Again, as you probably do know, the school is mostly run by volunteers who are often, full-time working attorneys such as myself. Of course, welcome the contributions of students as well.
I'm sorry, but your time is up.
Thank you.
Let me note in the audience, we have at least 8 people holding up signs that are expressing a similar sentiment, which we probably won't get to all of you, but I want to recognize that you came and you appear to agree with the speaker.
I think it's about 15.
And for our last online public comment, it's going to be from Sandra.
Good morning. This is Sandra Brooks from Cal Northern School of Law. I'm also the co-chair of the California Accredited Law Schools. And I have an issue I'd like to bring up today that is not on the agenda. It has to do with the annual report that the Cal's recently received just this week. And I want to appreciate your time and consideration to the written public comment that was presented yesterday to Donna Herskowitz regarding an extension of that November 15th annual report deadline. Normally, the CALs have 8 to 10 weeks to prepare to respond to the annual report. This year's delayed receipt, we only have 3 to 4 weeks. We ask for some flexibility for those schools that may need to provide extra time to provide accurate and thorough data. And if nothing more, at least a waiver of any punitive damages to any late fee. While the form is very similar to years past forms, this year's annual report form now provides a lot more written analysis regarding the policies and procedures of all of the law schools. In years past, we were able to check a box, yes or no, on half the report. If you had changes, describe the changes, but now they're asking for actual written statements and descriptions of our policies and procedures for the first half of the report, which is about 23 pages. So that alone will take a significant amount.
30 seconds.
So we just appreciate any staff flexibility that can be provided to those schools that may need additional time for that annual report filing deadline. Thank you very much.
Show of hands, are there people in the audience who are supporting basically those comments? 1, 2, okay, 3. Thank you. So let's go to that concludes the online comments.
Yes, it does.
Okay.
For our first in-person comment will be from Diana Cruz.
So my name is Diana Cruz. I'm currently a second-year student at People's College of Law. And truly, I didn't think I would be here before you today. And that's not only because I'm here advocating that the doors remain open at the law school, but because I didn't think I would ever become a lawyer myself. I see in 2018, my mother and I, and the entire building we lived in, received a 60-day no-fault eviction notice. The attorney that represented us in that case is the attorney that I work with right now. And it's the reason that I'm in law school. I truly want to work with housing and prevent that injustices like the ones that happen to my family, my neighbors, don't continue to happen in Los Angeles. And PCL is the only school that I can envision myself doing that at. There is no way I would have been able to afford rent at a conventional law school while keeping the roof over our heads that we fought so hard to keep. The culture at the school is unlike anyone that I've personally encountered in my own academics and colleagues that have been to other law schools as well. We all want to be people's attorneys, and we really hope that you will consider putting us on probation instead of terminating the college's ability to grant JVs. It is so inherently important for us to be at school. Myself, along with 2 other colleagues of mine here, my schoolmates say we passed the first-year law student exam on our first try. I myself got a published answer. So the school is effective. It is working. It is where we want to stay. So we really hope that you hear us today, keep the doors open. The school has a legacy.
30 seconds.
The school has had a legacy for so long, and it continues to do so long as, today you decide to keep the doors open, and that allows students like myself that would have been unable to become an attorney had it not been for PCL to pursue that dream that I didn't think was available. Thank you so much. And with that, put it in our favor.
Our next public comment is going to be from Bill Maesters.
Good morning, all. My name is Bill Maestas. Yes, hi. My name is Bill Maestas. I am a founding member, student of the People's College of Law in 1974. I was amongst the first. In that time span after, I have been an attorney for 42 years. I have practiced law in people's defense. I defended tenants. I defended people who were being deported on asylum application. I spent 30 years of my career doing criminal defense as an alternate public defender of LA County. I too, like the previous speaker, had no idea how I was going to be a lawyer. No idea. I didn't know any lawyers. The only lawyer I identified with was Perry Mason and the attorneys from the defenders, E.G. Marshall, heroes. I wanted to do what they did. And the only way I could be here speaking to you today was because of the existence of the People's College of Law. I could not get into law school. The most I ever got from any school was a letter from USC telling me that I had to apply for their paralegal program.
30 seconds.
That's what I got. I did not have the money. I did not have the background. I did not have, dare I say, the pedigree. And that's the kind of people that the school wants to develop into lawyers. I teach at the school and I am dedicated to doing that. Please don't take away from me.
Our next in-person public comment will be from Robert LaCruz.
Robert Lacara. Good morning. My name is Dr. Roberto Lacara. I'm a high school dropout from Sun Valley, California. I'm also a 3L at People's College of Law, and I'm in a unique position that I started my law school at Texas A&M, an ABA law school. I left on good standing. I went to the Monterey and Kern County College of Law. I left in good standing, and I'm at People's College of Law as a 3L in good standing. And I want to tell you, there is no drop off in the rigor of this law school. I completely love the pedagogy of the law school. And I can say, as a faculty member, former faculty member at USC, teaching teachers how to teach, their pedagogy is very, very good. There is no drop off. And what will happen to me? 40 years. And finally, so close to being an attorney. And if you cut off People's College of Law, I've been at this for 40 years. What's going to happen to me? Where am I going to go? I can't transfer their credits back to Texas A&M. So please, please consider doing everything you can for students like myself and my colleagues
30
to
seconds.
help us be an attorney. Thank you.
I believe our next public comment will be from Annabelle.
Good morning, members of the committee. My name is Anabella Bastida. I am a 3L, and also I serve the Coalition for Human Rights in Los Angeles, Chirla, as a full-time employee. I am here to speak on behalf of People's College of Law. People's College of Law is more than a regular school. It's a place where we have the opportunity to become people's lawyers. I am here to speak to you with all my heart. People like myself that have the dream to become people's life. As an immigrant, as a person that that English is my second language, I am here to tell you that this school, that these students have been providing me with the guidance, with the support that I need, the support that we need people like myself to really go and serve the immigrant community. You see the amount of people that are requiring services like this and the limitation that we have. So People's College of Law is providing me with the opportunity to pursue my dream, to pursue the dream of becoming a people's lawyer and also support my immigrant community. I am here to ask you for your consideration. We need to invest in schools like this, a school like this that provide us, people like myself, and people that work with the vulnerable people, the opportunity to really pursue our dreams. Thank you so much for your consideration. Don't close our school, but instead invest. Help us to serve our school. Thank you.
Our next public comment is from Gary. Gary in the audience. Oh, Gary.
Do you want to speak?
Is that me?
Yes.
Silviger? Free at last. Okay, thank you, everybody. My name is Gary Silviger, and when I was attending Southwestern Law School in the early 1970s, one of our members, attorney Hank DeSuvro, the great attorneys, came to us at the board, I was on the board, and in Los Angeles, and said, you know, we should try to start our own law school because the existing ones are not doing everything that, you know, law schools should be doing in terms of teaching and pro bono work and all sorts of things. If you went to, like at Southwestern, there were very few non-white students going there. There were very few women. In fact, one class I had, there was one woman in the class. So, you know, we wanted to start this new law school, which would have all the communities involved in law school and lawyering and helping people in the community. Of course, the rich have plenty of lawyers, but the unhoused or the working people or low income, whatever, it's difficult to find lawyers. And that's not equality, that's not justice. We want to have that at People's College of Law. That's what we teach. And a lot of our lawyers continue to work in their communities, other communities. But we had at least 4 people who became judges who graduated People's College of Law. There are more, I'm sure, but the ones that
30
I know
seconds.
and is Pete Navarro, Robert Leventer, Dean Franks, and Teresa Sanchez Gordon. And we've had other individuals who have been kind of interesting in what they've ended up doing. For instance, Antonio Villaraigosa, former mayor of Los Angeles, Gil Cedillo. And a couple of others whose names I can't remember right now.
I'm sorry, but your time is up.
Okay, thank you very much. Thank you for listening, and please work with us on what we're doing, this unique work that we're doing and charging law students, what they can afford more or less, you know. That's why some people can come to People's College of Law because they can afford it. And we're trying to help everybody make the society more just. Thank you.
Uh, 12.
Not all of us want to speak.
Yeah.
Okay.
Yeah, I know that you've all come to speak, but
No, we haven't.
we have to balance that with the need for the committee to be able to do its
Can you let him know that?
And so I'm wondering if some of you are willing to say you agree with the previous speakers, for instance. You seem to be, you are making basically the same point.
I think
We've advised that only 4 more additional individuals would like to make.
Sorry?
Only 4 more additional public comments from this group
Well,
would like to make a comment.
I'm not sure that's true. Only because of this. The other comments are going to be available. We can make other comments when our agenda item is called, correct?
You do it now or later, no double dipping.
Yeah, I got it. Okay, so it may be that there's more. Or I guess you're saying in the sign-up sheet, right?
But if you are speaking about peoples,
I am.
to speak later, you need to be like the dean or a representative of the school administration, not simply a student or alumni offering your support.
Yeah, but in your initial comments, you said we're gonna have 25 minutes. So what changed from then to now? Excuse me?
We are over 25 minutes.
Well, then
There's only three speakers, 2 minutes each.
In addition to our online public comment.
All right, if it's only representatives who can speak, and I kind of understand why later, then the rest need to speak now.
So we only have 4 more speakers.
We have 4 more from the People's College of Law.
I mean,
Okay, just have them go up.
To limit anybody's ability to speak, but, we have the other issue that we have a long agenda. We've got 4 rule packages to discuss.
Yeah, but this is important to us. So you guys have to listen to us, whether it's now or whether it's when representatives speak. We understand you guys have an agenda, and we hope we've been polite in our comments, and we just want an opportunity to speak. We're going to send 5 more speakers, and then the rest will speak in agenda items.
Is 4 speakers something that you could agree upon?
Sorry, project your voice, please.
We have 4 more speakers that would like to speak, not 15 or however many. Can we be allowed to have 4 more speakers?
We can allow 4 more.
Thank you. Thank you.
Kiara, then Magda.
We also have comments on any other item that's not related to people's. One person.
No.
Okay.
Chair, I wanted to clarify that the sign-in sheet we signed in thinking we just signed. I know that not everybody wants to speak, so I wanted to clarify that.
Oh, okay.
There's it's a small font, but it says sign in to provide public comment. So I apologize for that.
Nope.
Lack of clarity.
Okay, I just wanted to clarify that because it's causing so much confusion. Thank you.
I mean, in my career, I've conducted hearings where there are, 500 people in the room on a power plant case. And the point I like to make to the public is we don't count heads in making our decisions. So whether one person or 50 people make a particular point, it's the nature of the point and the validity of the point that's being made, not the number of people that make it. That helps you maybe realize that you can just raise your hand and what others have already said. I hope that helps. But go ahead and let's have the last 4.
Good morning. Hi, my name is Kiara. And at 18 years old, I was sentenced to 19 years to life in prison. I come from a community where either you're going to go to jail, you're going to die young, or be pregnant. And that's what we're told. That's what's embedded in us. I spent 14 years in prison where I gained 3 degrees and a paralegal certification. Ultimately, I would write the petition that would lead to my resentencing. And my sentence dropped from 19 years to life to 3 years, is which I should have gotten in the first place. When I got out of prison, I told myself I want to be an attorney. I want to make sure that people don't have to undergo or go through what I went through, that justice would be fair and it would be equal. And the only way that justice can be fair and justice can be equal is that there's more representation in the field, in the legal field. So when I got out, I applied to various law schools and I qualified to get into almost all of them. But none of them would accept me because the stigma attached to having someone that is formerly incarcerated at their university. And so I applied to People's College of Law, and they were the only institution that would accept me. And they looked past my past and saw that I was capable and able. I just finished my first year. I passed the baby bar on my first try. I got 84 out of 100 on my multiple choice, over 300 points on my essay, scoring an 80 and averaging
30
a 75.
seconds.
This school And the education that is provided at this school is top notch. So what we're asking for you to do is please not to terminate our school. Because if you terminate our school, what you do is you terminate the chances for people like me to become attorneys because other institutions will not accept us. Thank you.
Magda Madrigal. Magda.
Can't hear you.
Okay. Good morning. I want to thank the committee for this time and thank you for protecting the public's, the consumer interests. This body is very, very necessary. But I'm here to oppose closing down the People's College of Law. I currently work as a lawyer at Vexedic Legal Services. I don't speak on their behalf. I'm here on my own. It was a long road between deciding I wanted to be a lawyer and actually being a lawyer. All these things happen when you come from an immigrant family, working class, very little resources. And the only reason I became a lawyer is because of the People's College of Law. I represent people in eviction. Everybody wants to turn their face when they see a homeless person. How did that person become homeless? Somewhere there was an eviction, somewhere there was mental illness, somewhere there was something that they needed help with, and there was nobody there to help them. Last week, I got a commendation from my office because in 5 months, I got 19 cases dismissed, 19 unlawful detainers dismissed. I have been practicing eviction defense for 10 years at the various nonprofits in the MacArthur Park area, where nobody wants to work, where nobody wants to drive by. That is where I work. I work along people who have a student debt of $300,000. $300,000 is what they owe. And they're just doing their 10 years in the nonprofit sector so they can get their loan forgiven and then go on and become very, very rich people. I teach at the People's College of Law. I've been involved since I graduated. I teach legal writing. I do it for free because I want to and I love it. I should not be criticized because I don't want to take more money. I want to help make this world a better place. I urge you to not close the People's College of Law. Please keep it open. If it needs to be probation, we're gonna fix things. I was gone for a year because of illness.
I'm sorry,
and
but your
back.
time is up.
Thank you very much.
Pascual Torres, I'm an alumni of People's College of Law. I'm also an attorney. The California Bar has, over the years, started an initiative to bring access to lawyers to low-income communities. Terminating People's College of People's College of Law right to issue degrees will be counter to that initiative. As you guys heard, we're a diverse community. We're here. Our goal is to help people in the community. I'm an ex-gang member from East Los Angeles. I'm part of the homeboy industry community. And we got access. Who do we serve? Innocent people who served. A man who served 30 years in prison, pro bono work. Another man who served 23 years in prison, life without parole. We're helping him get resentenced, pro bono work. Another juvenile who was sentenced when he was, at 15 years old, he was charged for attempted murder. We're helping him out, pro bono work. We're providing access to low-income communities. Keep People's College of Law open. This is not about consumer protection. Consumer protection is a red herring. You heard from the students themselves. They want to be in our schools. Please keep open People's College of Law.
Good morning, committee members. My name is Ana Minauri, and I am a second-year law student at People's College of Law. I am a product of the continuation school system in Los Angeles Unified School District. I am a graduate of the University of California, Berkeley. I am an organizer in my community, and I lead a nonprofit organization that does important violence prevention and intervention work in the city of Los Angeles. And I chose to go to PCL because I would not want to pursue a legal education at any other institution due to the rich history of the school and advocating for those who other people do not want to advocate for. So I want to clarify that, as you've heard from my peers, we are not at PCL as the second or third option. Many of us chose to go to PCL because of the history of the organization and to be a part of the legacy of the institution. We have esteemed alumni who represent us as state officials, such as Senator Maria Elena Durazo, who just passed important legislation in the state of California. We have public defenders on our team, as many others have spoken, but I am proud to be a part of PCL. I know there's a lot of improvements in the infrastructure that need to be made, but I hope that you all will trust in the leadership that you all have heard from today and empower us to continue building towards the legacy of PCL and make it a better institution for the next generation of people's lawyers that will come after I came. I also passed the first-year law student exam on my first attempt in June. And I am excited to continue being a part of the school committee, continue to organize to get important attorneys, such as some of those that you have heard of, to continue volunteering their time. And
I'm sorry,
being a
but your
part-
time is up.
Sorry, can we have one more speaker? I miscalculated initially.
Last one.
One more and that's it.
Promise.
Promise.
Good morning, thank you. My name is Fredericia Dixon. It is a true honor to be addressing you all today and to be putting forth my support for People's College of Law. I am a board member with the National Lawyers Guild. I'm also a legal fellow with Law for Black Lives. And I am also a mayoral candidate in Inglewood, California. Prior to me being developed into the woman and the community advocate that I am today, I am a single parent. I am a college dropout. I am a first generation college student, and I'm 2 generations removed from chattel slavery. I also helped start the Black Lives Matter movement. So in 2014, I got really engaged and involved in community activism and organizing. And from putting my body on the front line and fighting for my community, I realized that I needed to educate myself more if I really wanted to be impactful in my community. As I mentioned before, single parent, college dropout, there was no way that I was going to be able to afford to go to law school, and I didn't even know a clear path to that. However, I was privileged enough to meet some of the professors and some of the students from People's College of Law. I applied and I was accepted. I too passed the first-year law students exam, and after passing the first-year law students exam, I transferred to another law school, which is where I received my Juris Doctor degree from.
30
I
seconds.
mentioned all this to say that People's College of Law is a law school that this community needs. They're developing attorneys that are there to champion human rights issues and to really serve this community. Most people think of lawyers as being elitist and people who are capitalists, but that is not the type of attorneys that are developed at People's College of Law. So I come to ask this board today to please support us and please support People's College of Law. Please allow us to be on a probationary period while this community gathers together so that we can resolve the issues.
I'm
that
sorry,
we
but your
have,
time is up.
and so that we can continue to grant Juris Doctor degrees and we can continue to develop people's attorneys. Thank you very much for your time.
Thank you. Those public comment. And I want to just explain a change of schedule. We're going to adjust the agenda a bit today to accommodate the Office of General Counsel, which has a schedule conflict. So we're going to hear the remaining matters under the chair's time on the agenda and then the director's reports, and then go into closed session to hear the first item in the closed session agenda, which is the council's report. Then we'll come back to complete the open session items. And finally, we'll go back into closed session to complete all the remaining closed session items. So with that, the next item is recognition of our outgoing chair. And I want to personally thank our former chair, Alex Lawrence, for his service to this committee. I've worked closely with him over the past year as his co-chair and experienced firsthand the effort he put in to advocating for our having the information that we need to do our jobs as committee members. All of us have experienced his even-handed stewardship of our long virtual meetings. the past year. This is not to say goodbye, however, because he remains on the committee for. He remains on the committee for at least another year, maybe a couple more, as, I don't know, if you consider it punishment or not, but we really enjoyed working with you. We will enjoy continuing to work with you. And I think eventually we will have a nice frame.
Mr. Chair, if I could just make one quick comment. So I have enjoyed my time being a part of the committee, and I know it's been very challenging, sort of especially in the last 3 or 4 years, and navigate a lot of different formats with the COVID period, fires, a lot of interruption, but definitely appreciate the time and support from a lot of all of the members and the staff, and look forward to your own leadership in this new era that we're going into. So thank you again.
Thank you. Okay, the next item is it's O101. It's the committee assignments for this upcoming year, 2022, 2023. You'll note on the list that there's a couple of placeholders because we are down 2 members at present. We're expecting that the Supreme Court will appoint replacements for Judge Terrell and for Michael Lazari in time for them to be with us at our December meeting. They have pre-assigned spots. I guess they could flip the coin to see if they're going to be number 1 or number 2. We'll work that out. Okay, so there's no motion required to approve that. The next item is the appointment of members of the Law School Council and the Committee of State Bar Accredited and Registered Schools. Natalie has the details there. We don't have an attachment yet to.
I will be showing the composition of the community. Oh, sorry. How's that volume? Okay, great. So the Committee on the State Bar Accredited and Registered Schools and the Law School Council each have their members appointed by the chair and vice chair of the State Bar Examiners. This year, that would be Paul Kramer and Dr. Michael Cal. We are happy to present the new members selected for this year. Regarding the CS bars, the chair will be Linda Keller from Thomas Jefferson School of Law. She is already a part of the committee and has served actively this year, including part of the editing for the 1.1 guideline that you will see today. Also newly appointed this year is Dean Kevin Marshall from the University of Laverne College of Law and Government Policy in Laverne, California. And I'll ask Devin to see if they are attending. And if so, if they could be recognized to greet the committee. But while she's doing that, I'll ask Audrey to proceed to the next slide.
Why am I on
No, actually, you will be, Ajane will be attending in your place, so we need to adjust that. So in the new year, the chair of the subcommittee will be.
Greg Murphy leave as well?
Excuse me?
Greg Murphy?
Currently, he remains until there is an alternate.
Okay, so we're working to find an alternate for Greg Murphy. We're looking for somebody who has some expertise in accreditation.
Yeah, so I apologize. Yes, after serving ably for multiple years, Chair Paul Kramer will attempt his time to being the chair, and Dr. Don Ajane Wilcoxon will take his place on the CS bars. As far as the Law School Council, our new chair will be Nidia Dueñas from the Southwestern Law School. Also, new appointee Mary Basic from UC Irvine School of Law will join the committee as well. Devin, do we have any of those members present to say hello? If so, they would have raised their hand. Linda Keller, Kevin Marshall. Linda Keller just raised her hand. She's going to get on the mic. Linda, you're unmuted.
Hi, thank you very much. appreciate the opportunity to say hi. I look forward to working with everyone as chair of CSBARs in the upcoming sessions. And I will just add, someone asked earlier to see if Zoom captions could be used. I would second that because it is a little bit hard to hear what's happening in the live room often. Thanks.
Soft-spoken people need apply.
Good point. I'll do the best that I can. And then, do we have Nydia or Mary in attendance raising their hand?
I don't see any other raised hands.
Okay, thank you. These committees meet throughout the year. These committees meet throughout the year to help advise the community bar examiners, and we appreciate their efforts. We encourage the law schools here and listening outside to participate in those meetings, to watch via the webcast, and also to provide public comment to those meetings. Thank you.
Okay, any questions about committee appointments? Okay, next item is that's approval of the minutes from our last meeting on August 19th. Does anybody have any comments or corrections?
This is Robbie. I'll move to approve the minutes.
I'll second.
And a procedural question, we're sort of half Zoom, well, 1/10 Zoom, mostly in person, we still have to take a roll call vote.
Yes.
Okay, please take a roll.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan? Jim Epting?
Yes.
Kareem Gandora?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Lori Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Bethany Peak?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon?
Yes.
The motion passes.
Thank you. The next items are under the director's report.
Thank you. So Tyler has a presentation that you can pull. The PowerPoint. All right, so starting with the first item, this is a report on the key statistical indicators. This is a report on the period between August and September 2022. And just as a reminder, the key statistical indicators report capture the number of applications received by the Office of Admissions to date, along with a comparison to last year's count. This is a reporting period, as I mentioned, from for August and September 2022 compared to 2021. The following applications experienced a 20% change in that comparison year. So here, as you can see, and some of this, I report this at every CBE meeting, and some of you might have see a pattern here. Starting with the number of applicants placed on the motion, we have 68% less people placed on the motion for this period compared to August, September 2022 compared to August and September of 2021. And what that reflects is the fact that the October 2020 bar exam that postponement delayed the results release. So rather than the results being released in November of 2020, they were released in 2021. That's really inflated the number of people placed on the motion in 2021. So this will fade away by 2023. As for the other statistics, this includes the number of applications that we received for the general bar exam and for the attorney exam application. There's been a decline. That's been steady from one meeting to the next. So again, just the difference, general bar exam is the 2-day exam, the attorney examination is a 1-day exam. And part of what could explain this decline is the fact that in 2022, we had in-person bar exams. When in 2021, we had remote exams, we experienced many more applicants than we did in 2022. The next the next set of applications that have more than 20% decline or increase are the moral character extensions. Here we see a 44% decline in 2022 compared to 2021. And that can be attributed to the fact that we had an increase when the provisional licensing program was made available. So that could explain why there was a decrease this year. And then the last item is the multi-jurisdictional practice. There's been a steady incline in terms of the number of applications that we've been getting throughout the year in multi-jurisdictional practice altogether. So that's a 54.9% more set of applications this year compared to last. And to remind everybody, these applications registered military spouse attorneys, registered in-house counsel, as well as registered legal aid attorneys. Are there any questions about the key statistical indicators? Okay, we can move on to the next item. This is an update on the provisional licensure program. So on Monday, October 3rd, the State Bar released a survey at just 3 separate groups: current and former PLLs, supervisors of all current and former PLLs, as well as those provisionally licensed lawyers, people who were eligible for the program that did not participate. And the purpose of this survey is to help inform the State Bar's recommendation to the Supreme Court about whether or to continue either of the PLL programs, that is the program that's based on graduation date, where people are eligible based on graduating between December 2019 and December 2020, or those that qualify based on having a passing score from July 2015 by 2020, new passing score of 2020, either during the first read, second read, or as your final score. So the idea is to learn from these candidates about their experience in order to make that determination. It'll also help inform the Blue Ribbon Commission on the future of the bar exam and the California Supreme Court on their assessment on whether to study and develop a new pathway to licensure that does not include the bar exam. So the survey itself was conducted in collaboration with Office of Research and Institutional Accountability, and also 2 external researchers. So where we're at now, the survey is scheduled to close on Friday, October 14th. So today is the last day that we'll be collecting surveys from these applicants. And also in terms of the recommendation, the State Bar's recommendation will be made on or around December 1st. And if the Supreme Court, it allowed time for the Supreme Court to respond on whether to extend that program based on the final analysis. Any questions about the provisional license program?
My apologies, back in the first part, will it be continued for another session, or will it be continued for another
The
session?
program itself?
Yes.
That's what this assessment is going to do. It's going to help, identify whether that should happen or not.
Yeah, I'd like to see a copy of that report.
Oh, sure. I'll make sure that we circulate it here when that report is ready.
Are we going to vote on the recommendation for the Supreme Court?
We didn't talk about that, but no, probably not.
It's probably one of those things where there's not time. It's good. As we so often ride close to the deadline. It's okay. All right.
Any other items, any other questions related to the survey? Okay, the next item is the update on the rules revision initiative. As you noted on our agenda, we have a set of rules revision. Just to remind everybody about the process itself, it began as part of the Office of Admissions Process Improvement Initiative. Our goal was to investigate areas that need further instruction, clarification, revision, either to our current material, whether that's on our website, material made available to the public, or material that we share with staff as part of the training process. The end goal again is to improve the application process for our applicants. And so we started with the items that you'll see on our agenda today. And so now, and we did this also by assessing on a unit by unit basis, areas that had a high concentration of public inquiry, as noted here, areas where there might be a misinterpretation by applicants. And one of the categories also that, as we were combing through our processes and getting feedback from staff, are areas, rules that needed to also get revisited. And so, can we go to the next screen? So we, as part of that process, in some of these areas, we've identified areas where a proposed rule might be necessary. And we, our intention is to work with the CBE members to develop a set of recommended changes. And that's how we came upon the rules proposals that are put before you today. Our goal for our next areas include exam grading and exam administration. So as we look at proposals in this area, we want to create a little bit more time in the schedule than we did in this for this initial round. So I'm going to send a follow-up email to find out if we have anybody, any volunteers that are interested in helping in the next two agreements, which include exam grading and exam administration. And once CBE members are identified, we'll meet with the CBE members on initial thoughts and gather their input on getting a draft of an item. And so volunteering is going to involve participating in multiple meetings to provide input on the proposed rules that are being drafted. And we're building, as I said, more time into the schedule so that to ensure that the drafted agenda item reflects the conversations that are taking place with CBE members and staff. So with that in mind, I will be sending a follow-up email after this meeting to solicit volunteers from this committee for these two areas.
So when you say adding more time, one of my concerns about post happen today is that while we have two members, and actually three, because I looked at all the items as well, just inserting myself, we can't necessarily be representative of all the concerns that the committee might have. And so I think it's very difficult for a package that 2 or 3 members have reviewed to come to this body with the expectation that we're going to just turn it around and approve it on the same day. We need time to let other people think about it. And, you know, we're likely to get some other good ideas or thoughts from people who are not involved in that initial process. So are you saying that you're going to try to present the concepts and the draft at one meeting and carry it over to the next meeting for final action? That's the general approach?
Yes, so sorry to get into the weeds on this, but the process that we're envisioning is as soon as we identify the volunteers for the next assignments, staff will meet with the volunteers, 2 CBE volunteers, talk about what our initial thinking is based on being early in the process, where we are now, solicit your feedback based on things that you've heard in these CBE meetings or the experiences that you've had. We'll talk about areas where we think we will learn more. So for example, you know, in the evaluation of moral character, staff went and looked at moral character applications every other state to see what things other states don't, that other states don't. So we tell you, this is our plan, our research. Yes, we're going to staff are there other suggestions that you have, things that we should be doing? We'll then do that research and based on that conversation and our further thinking, come up with a proposed rule. Meet with the volunteer, go over the two volunteers, go over those proposed rules, make any changes based on that subsequent meeting, draft an agenda item, share that with the volunteers, get your input on that agenda. Then we can schedule for a CPE meeting. So for example, the exam of grading and administration in our mind would be scheduled for the March CPE meeting with a possibility if we need a follow-up meeting that we could then follow up at the April CPE meeting, which would still enable us to go to the meeting with your recommendations about the public comment in May. One of the constraints that we have in this scheduling is that the Board of Trustees is focusing their May meeting and their November meeting on rules proposals. So if there's an urgent need to hear for the Board of Trustees to hear a rule proposal outside of that schedule, they will of course consider that. But we are trying to build a schedule for your work that gets us to a May meeting or a November meeting. But as I said, Paul, in specific answer to your question, yes, the plan for all of these is that it would come to a CDE meeting, and then there's the opportunity for a follow-up meeting. Should the committee determine based on that first discussion, we need some more time, we want some changes, we want to see those changes, we don't want to edit on the fly, and that opportunity is what's built into that schedule.
This is Robbie. Paul, I generally defer to you with these matters, but I think that this plan is right on with the right members. It's just too unwieldy to have everybody at every stage. And maybe you would like to be the one to solicit those people that will be working with staff on these projects, or maybe working with Amy on choosing the people that will best be able to. I'm going to volunteer for this, and I've worked with Donna on prior things with David, and I thought it was very effective. We can't do it all, but I'm pretty confident that just about everybody at this table would do a good job to work with Amy and staff to make a presentation to the full membership, just like we're going to do today. So I know it's not ideal. It's nice to have, many sets of eyes looking at it, but I don't have a problem with selecting. And as I say, maybe you want to be a bigger part of that. Maybe the chair of the CBE should always be a bigger part, designated just like you do for the subcommittees.
Well, I don't know that I need to be. Like, for instance, I think my core competency is proofreading and nitpicking the rules. Right? So, repetition.
Yeah, agreed.
But my only concern is that we might fall into a posture where two people are attempting to represent the views of all of us, and we feel kind of reluctant to raise our own questions when it comes before the full group. But I see the value in having two people work with staff to, they're going to get at most of the issues, just maybe not all of them. And we need to have in our minds allowed time so that we can take a little bit of time out to deal with a concern that somebody else comes up with, that is legitimate and should be dealt with. Okay. Is that all that one? Any more about that? Let's go to the next one.
So one last item before I turn it over to Leo Wilson. We are, I just want to give everybody the heads up that for our December meeting, this is a recent development, we are going to be in person once more. It's going to be a 2-day meeting, because at that meeting, we'll be doing orientation and planning, and also question selection is happening. So just giving everybody the heads up. I will send out some more information about that, but it's scheduled that's our schedule for December.
The question selection is only licensed attorneys.
Yes.
And that's usually on Saturday.
On Saturday.
Yeah.
Like me,
No, the point here is that it's going to be enough business that it's going to, the non-question selection business is going to swap over on the Saturday. So for public members and attorney members, we're all going to be here for 2 days. And just several of us met for dinner last night, or just to have a social event, to see each other sometimes for the first time. And this will give us an opportunity to do that on that Friday.
so of course, so the Saturday, the general session, and then after that, questions.
Well, I'll probably start with question selection, so you guys can sleep in
Okay.
a little bit, and then we'll try to pick a time, maybe like 10:30. We'll see, but where we will not expect you. And the other aspect of the December meeting is that I moved up the planning session that we have annually from the January meeting, where it's traditionally been, to December, so it's closer to the start of the year, which makes sense to me. I often wondered why we were halfway through the year and we were talking about planning. So that's a time for you to bring your ideas. I think we're going to hear about budgetary limitations in a minute. We may not be able to do everything we would like to do, but I would at least like to know what we would like to do, recognize this, and maybe we have to prioritize what the resources to be. So we talk about planning in a way every meeting, we go over the goals for the subcommittees, but this is a more focused time to do that. Be combined with the orientation, and we'll be thinking more long term than short term. So, gather your ideas, and bring them. If you want to tell me about some of them ahead of time, then that'll help me plan the details of the planning sessions. So be sure.
All right, so with that, we'll move on to the next item here. I want to introduce our Executive Director, Leah Wilson, who will be presenting on the State Bar's 5-year strategic plan, 2022 through 2027.
Okay, great. I hear a lot of feedback. Can people hear me? Yes or no? Okay.
Yes.
So I'm really looking forward to having this conversation with all of you. I do have a hard stop though at 11, and Paul, you sent I think some questions that suggest, there is a need for some discussion. And so I did want to offer the possibility of perhaps having this conversation at your December meeting as part of the planning session. Happy to do it now, happy to walk through the overview of the strategic plan, but I just want to make sure that I don't, curtail conversation that we should have, or, the ensuing discussion after the PowerPoint isn't going to be too abruptly cut off, given that I have a hard stop at 11. So I don't know, Paul, if you have any thoughts on how you want to proceed.
Why don't you give the higher altitude look today, and then I appreciate your offer to come back to us in December. I think we would appreciate your signature. So make it shorter than you might have otherwise. But I think it will, as we're thinking about December, to go over what we're going to do this today.
Okay, great. So I'm going to share my screen. And as Amy mentioned, I'm going to give everyone an overview of the new 5-year strategic plan. And here I'm really going to focus primarily on those aspects that directly relate to the work of admissions. The plan is organized into 4 goal areas, all around the central theme of protecting the public. And so you can see the 4 goals here. Strengthening the attorney discipline system, enhancing access to and inclusion in the legal system, and it is in goal 2 that will be primarily focused today. Regulating the profession and engaging partners. I want to highlight as well a change from previous strategic plans, which had a separate and distinct section on diversity, equity, and inclusion. This go around, we have as a foundational principle for the plan in its entirety a commitment to DEI. And this is not just DEI in the profession, but in the state bar itself, as we are in fact an employer. And so there are many aspects of the operational activities that underlie the plan that focus on the state bar as an employer. So as I mentioned, today I'm going to focus on goal 2, increasing access to the legal system through outreach and education. And the goal is accompanied by a vision statement. And so you can see here that the board's vision is that all California residents have access to high quality, affordable, and culturally competent legal advice and services. Each of, I'm sorry, did someone have a question or? No, okay. So each of the goal areas is accompanied by strategies, and the strategies really speak to how we are going to accomplish the goals. The strategy categories are the same for each goal area, meaning DEI, policy and systems change, effectiveness, and consumer focus. So here you can see on the screen, I'm not going to read all of this to you, and I will provide the deck to admissions staff so that they can send it to you. But you can see here in each of the areas, the specific strategies that the board has identified in order to achieve the goal and ultimately to work towards achievement of the vision itself. We're going to focus on a couple of strategies here. So in the area of effectiveness, increasing the number of attorneys admitted through special admissions. At the operational level, which is one step below the strategic plan, here staff has begun the work to delineate what are the specific activities that will be undertaken to achieve that strategy. So the strategy is to increase the number of attorneys admitted through special admissions. And here we say operationally, what is that going to look like? And something important to understand as we go through this slide deck is that the operational activities have been developed by staff. They comprise an operational plan. That plan is not something that has been approved by the board. In addition to that, it will change and be updated on a fairly regular basis. At this juncture, we're planning twice a year because we simply did not plan out 5 years worth of activities to coincide with the term of the strategic plan. So we need to think about the operational plan as a living document. And when you think about your own planning session, I think to have that in mind, that operational activities, ideas that you may generate might find themselves in the operational plan update, and that the first update that will occur will in fact take place in January of 2023. So for now, the operational activities that have been identified are submitting recommendation to the Supreme Court regarding the PLL program expiration, something you heard about and discussed briefly earlier this morning. Then here you see there's really a focus not on the entirety of special admissions programs, but on registered legal aid attorneys and registered military spouse attorneys in particular. This is because of the emphasis in the plan overall on increasing access. So some of our special admissions programs, you know, are more geared towards corporate counsel, kind of corporate clients, the private bar, and the focus, however, that we are taking is on those particular special admissions programs that increase access. So legal aid attorneys and military spouse attorneys. The idea is that this work will be done jointly between the Office of Admissions and the Office of Access and Inclusion. So you can see an effort to identify barriers that currently exist with respect to these programs. And that identification of barriers will obviously inform recommendations for policy and rule changes. And I imagine all of that would be worked on by the committee. Revise bar admissions requirements to be more relevant to the practice of law in alignment with the recommendations of the Blue Ribbon Commission. I believe you will be discussing the Blue Ribbon Commission recommendations or the status of that effort during your meeting today. There was a sort of a exciting subcommittee meeting yesterday that I'm sure you'll hear about. The operational activity is to submit the final Blue Ribbon Commission report and recommendations to the Board of Trustees. So we don't know exactly what those recommendations are going to look like, other than at this point, the commission has voted to recommend a new bar exam, so sort of a California bar exam. And that obviously will mean significant changes for the tests that we deliver, the content, the format, and the delivery method. And all of that is work that I imagine the committee will be very involved in over the period of this strategic plan and possibly taking us into the next 5-year plan. Another kind of strategy here is increasing the numbers of diverse attorneys in the legal profession through diversity pipeline programs. As an operational activity, you see referenced here is a lot of the work that you'll also be discussing today to look at testing accommodations processes and how we ensure equity and access for test takers with various disabilities who need to be able to take the exam and sort of thrive in the exam environment. Also here in the operational activities, you see a focus on collection and reporting of data from the law schools. And I think we had a public commenter speak to the timelines for submission of some of that data. And this, my understanding is, this is the first year that we are collecting a really rich and robust data set, both from the accredited schools, but also from the registered schools. This is important work, and it will enable us to provide comparative data, frankly, between not just our California accredited and registered schools, but also how we measure up against ABA schools in important areas like retention, graduation rates, et cetera. And so this too is work that I see actually in your current CBE work plan. Also, I think an access issue kind of very related to the previous strategy, but here you see something specifically addressing the Mindsets in Legal Education initiative. I hope you all are aware that in the 2022 State Bar budget, we have funded this program. So we've institutionalized funding for it, no longer requiring the providers of the support or intervention tool to raise funds and use grants to fund it, but instead the State Bar is funding the initiative. The operational activity here is to explore expansion of this initiative to first-year law students. We also want to figure out ways to work with law schools to encourage broader participation in the program, because this is an evidence-based bar exam pass program. So we want to ensure that folks are accessing it. Another strategy is to look at various options for administration of the bar exam. And here, what's called out in the strategic plan is looking at remote and open book formats. We've heard quite a bit in various Blue Ribbon Commission meetings about other jurisdictions that do have open book exams. And you know that we had 2 years of remote exam administration. And so here we're kind of looking at how these different modalities for administering an exam impact not just pass rates overall, but impact different populations of test takers. The operational activity is to complete specific studies on bar exam administration modalities. We've received 1 grant and hopefully 2 grants shortly from Access Lex to study increased, I think, time for certain questions on the bar exam, remote administration, and an open book format. And this is work that will happen next year. And I'm sure if you haven't already been briefed on that, you will, but this is sort of the immediate operational activity that has been planned in association with that particular strategy. Another strategy, there's two here related to bar exam proctors and graders. So this one is implicit bias training for these populations. So just institutionalizing annual training. And then specifically for exam graders, although I think this may be exam developers, to share guidelines for eliminating bias on exam questions. So there's been, as you know, the diff analysis done of our bar exam questions. And although there were no significant differential impact findings, there were recommendations about ways that our bar exam question development process needed to be changed. And so part of that is providing guidelines on question development. So these operational activities here really suggest a continuation of work that is already being done, I think, rather than new initiatives at this time. Similarly, you see a strategy to continue to diversify the exam development and grading pool. And here, operational activity, develop a pipeline from the grader pool to the exam developer pool, and also to begin to report grader and exam developer demographics as part of our State Bar annual report. I hope you all know that we do publish an annual report. We've started that, I think this year is the 3rd year. It's in an all digital format, and we do include a metrics section. And so here this speaks to providing those demographics in the metrics section of the annual report. Another strategy that's very interesting, this is in the area of policy and systems change, is to collaborate with legislative and other stakeholders to establish a law school student loan forgiveness program. This last legislative session, there was quite a push by the California Commission on Access to Justice to have this type of program funded. I think there was high hopes that it would be included in the final budget approved by, signed by the governor. It was not, but I don't think that the movement has died. And in fact, there is some effort underway to work with law schools to perhaps self-fund a more centralized and structured program that will allow law students to take maximum advantage of the tax benefits or not have any tax liability associated with receiving loan forgiveness benefits. And so this is sort of policy work that's underway in collaboration with the Commission on Access to Justice. And here I just spoke to some of the work here, self-funded and working with law schools. Now we move to also in the area of policy and systems change, the law school accreditation process. Collaborate with stakeholders and law schools to improve the process. We have some specific operational activities here related to the development of performance metrics, implementation of recommendations from the law school retention study that is underway or recently completed, but I don't believe has been published. Though some of those recommendations may be appropriate for inclusion in your accreditation processes. And then here you see a specific activity related to unaccredited law schools and looking at the rules and guidelines that apply to these schools. I do see in your current work plan some reference to work to review the accreditation process, and I look forward to working with you all to flesh out these rather ambitious goals that are outlined here in both the strategic plan and the operational plan. I'm going to move now, I've kind of covered, and I hope you see there's quite a bit and admissions focused in the strategic plan. I'm going to talk a little bit briefly about Goal 4. Goal 4 has to do with your function and role as a committee of the bar. And so I'm going to, when I give the strategic plan overview to each committee or subentity, I'm always going to go over some of the key aspects of Goal 4 that I think are relevant to your work. And you can see here, we have a goal and we have a vision statement. So I'm going to move. Similarly, we have strategies in Goal 4, DEI, policy and systems change, effectiveness, and consumer focus. So I'm going to move to the first one, enhance visibility and accessibility to State Bar meetings. And how are we going to do this? First of all, as you can see, as you know, actually, we are continuing to have a majority of our meetings remotely, with in-person meetings in a hybrid format, meaning that both members of the sub-entity and public, those who wish to make public comment or just observe the meeting, can participate in person or by Zoom. And so we really want to, one, understand best practices for remote meetings, best practices for hybrid meetings, and really track what is happening at these meetings. So for example, today we had public comment in person and public comment by Zoom. We are tracking the numbers, we're tracking any issues that come up and comments related to how our meetings are functioning. I think we heard two people talk about Zoom live captioning. My understanding is we do not always consistently use Zoom live captioning, but as part of our early efforts in this area, as staff has identified that as a practice that many other agencies use. And so likely we will be recommending that that be institutionalized for all of our sub-entities. Similarly, we've had a request to promulgate guidelines around having camera off or on. Some concern about folks that this is really for sub-entity members that might participate in an entire meeting with their camera off. So here, rather than going into the detail of these particular operational activities, wanted you to know that there is a very intentional focus on how we conduct our meetings in a way that maximizes the ability of both members to participate and the public to participate and to use best practices with respect to both. Also here in goal 4 is really, I think, an ambitious idea for the bar to serve as an incubator for innovation and to share our successes and best practices. And I'm sharing this one with all of the sub-entities because I'd like you to think about the work that you've done that you are proud of and you think that we should be highlighting. You can see in the operational activities, the second bullet references the State Bar's 100th anniversary, which conveniently coincides with the terminus date for this 5-year strategic plan, 2027. We will begin actively planning for our 100th anniversary in 2025. But part of that work really will be for each area of the bar to start to begin to document some of its own history. And as I said, work and accomplishments that you're most proud of. And so I'd like to just sort of get that idea in your head, particularly for those of you who have been working in and around the bar for some time. Goal 4 also talks a lot about, and I don't know if you recall, my shorthand summary for this goal was engage partners. It talks a lot about partnerships with other organizations and entities. And so here, I really sort of, want you all to think about what kinds of partnerships have you established as a committee, and do you think would be appropriate for us to establish, not just sort of with the traditional entities that we might partner with. And in this category, I would put, for example, law schools or admissions related organizations like the National Conference of Bar Examiners. Are there other types of partnerships that might make sense? We heard today, for example, some very compelling, I think, public comment from folks who have experience in the criminal justice system, who have sort of made significant changes in their lives that enable them to become lawyers. Well, the State Bar does not have many partnerships with criminal justice organizations or organizations focused on rehabilitation or reentry into the community. Are those partnerships that we should have? Those of you on the committee, you come from many varied backgrounds, and that's, I think, the part of the value that you bring. And I really love your best thinking of who should we be partnering with, engaging with, seeking feedback from that we aren't currently doing so. Operational activities here that I'm not going to focus on because I just spoke to them. Another important focus in this plan is on transparency. And I mention this because you may see changes in terms of the amount of information that we are sharing publicly, both proactively and also in response to media inquiries. And so I think as you're doing your work, it's important to understand that being a transparent organization is an expressed key value of the Board of Trustees. And so as, again, as you're undertaking your deliberations and certainly making decisions about directions to go in, we want to lean into being as transparent as possible, not just with respect to decisions that are being made, but the why they are being made. Another important strategy here is to expand multilingual content and outreach. I don't have a lot to say here. It's fairly self-explanatory, but you will see a lot of movement towards at least expanding our content availability in the 6 key or top languages used in California. This is another partnership related strategy. I'm not going to go into it in the interest of time. And then lastly, I'm going to talk about sort of engaging diverse voices in the development and evaluation of state bar policy itself. So this particular strategy here, we're really talking about the membership of our sub-entities, at least in part, as well as a significant effort to reshape the public comment process. So first of all, we have a board that is extremely interested in maximizing the number of public members on all sub-entities, non-lawyer members. And you will see sort of an increasing focus and attention to a non-attorney membership. You may even see coming out of this board recommendations for rule or statutory changes to increase the numbers of public members where those numbers are capped by either rule or statute. So that's an important piece I wanted to emphasize here. In addition, our public comment process heretofore has been quite, I think, inaccessible. We do not use plain language. We don't have a sort of broad and expansive outreach in terms of who we're trying to get public comment from. And we've begun to change that, particularly with some of the items that have gone out for public comment from the Board of Trustees. I mean, I think you will see an increasing focus on the public comment process itself, attention to who comment was sought from. We don't want to just hear from sort of the same voices in the room that we always hear from, or from those folks that are most immediately impacted in or interested in a particular issue. But the idea is to expand the voices that are involved in state bar policymaking. So with that, I'm going to stop sharing. I'm sorry, I've been talking at you for quite a bit. I will share the slide deck. And I've got about 4 minutes for any questions or reactions, or however, Paul, you'd like to kind of wrap this piece up.
Thank you. I look forward to seeing you in December. We'll flesh some of this out. And as soon as you can get your materials, which are different than what we had in our attachments, to help us start thinking about our December planning session better.
Okay.
I had a quick comment.
Oh, sorry,
We have
Greg
4
has a
minutes.
question.
Yeah, if I may. Thank you so much for the presentation and for your vision and leadership on directing that. Leah, I personally appreciate it. I've been involved in the DEI space for quite some time. And so I've heard a lot of speak of it. And so it's good to see us codify it and actually put it in a place where we'll have results and outcomes. I guess for me, maybe for our bigger discussion in December, is what budgetary allocation is going to be provided to ensure we create those outcomes and we have those indicators to show that we're making progress. I like what we've been able to see thus far. I think the team's doing a good job. I just think the next 5 years are very critical to the path that we're charting forward. So brief comments, but I just wanted to say thank you.
All right, thanks.
Okay, thank you, Leah. See you in December.
Okay.
Hey, we've been at it for probably an hour and 3/4. So it's time for a break. Let's take a 10-minute break. Actually, let's bring us back at 11:10. And one more report on the director's report. Do that. Read the closed session.
Particularly on law firm partners and shareholders. The question on the survey was, are you a law firm partner or shareholder? And what this shows here is that women are 42% of all attorneys that work in law firms, but they are only 31% of attorneys, law firm attorneys who are either a partner or shareholder. So therefore, women as a group are underrepresented among law firm partners and shareholders. Same thing with people of color here at the top. They're 31% of everyone who works in a law firm, but only 23% of law firm partners and shareholders. This next slide looks at, okay, so among this group of attorneys who are a partner or shareholder, what type are they? And that was the specific question. Are you an equity, a partner or shareholder, non-equity, a non-tier partnership, or other? And here at the top, here's our total group. And as you can see, 74% of attorneys who said that they were a partner or a shareholder said that they were an equity partner or shareholder. And you take that line all the way down and you can see which groups are less likely to have that type of partnership or shareholder. In particular, white women, only 66% said that they had that type of partnership. And another group, a women of color, only 64%, and non-binary attorneys of color, only 63%. So here's where you see disparities. In this case, we looked at disparities among everyone who said that they held this, what percent had this? And that's a different way of looking at disparities than we did before. Okay, so finally, I'm going to share some results with regards to our workplace satisfaction survey items. Attorneys were presented with 15 items here that ask, how satisfied are you with regards to this area of your work life? And we were able to combine these 15 items across 3 domains. Here on the left are a series of items that have to do with attorneys' individuals' careers. The one in the middle has to do with issues that pertain to more of a collective workplace experience. And here on the right has to do with specifically workplace balance. And just, I know this chart's a little busy, but hopefully you can go look at it in the report. But the way you interpret this is that this is the percent of all groups that said that they were satisfied with that domain. Again, combining all those survey items to try to make a bigger statement about individual career and collective and workplace balance. So the way you interpret this is that 62% of attorneys said that they were satisfied in general with those survey items as outlined with regards to individual career. And then we have this data for all the different groups that we're interested in exploring. So wish I had a line here, I don't have it. Okay, but as you can see here, let's just look at this gender identity. Well, the one thing we noticed is that you choose a group and you look across, and what this showed is that non-binary attorneys are less satisfied with them compared to men and women.
Yes, our whole department.
Okay, all right, so let's see what else I have here. Okay, so we conclude the report with a series of what we call calls to actions. And this is where we provide talking points, really just like, directives to employers and attorneys. Okay, given all this data we've shared with you, given these findings, what can you do to remedy the situation? And so we have that. And then one thing that was new for this year, like I said, this is the second time we've produced this report. We produce calls to actions for different sectors. So we have one for private sector employers, government sector employers, and nonprofit sector employers. And here on the right is one specifically for attorneys who are wanting to do something about this, these disparities and all the findings that we found in this report. Okay, so thank you so much. I'll take any questions you may have.
Any questions?
Hi, Lisa. Thank you for your report. This is Vince Reyes, member of the CB. I know it's you haven't shared everything because you know. What I want to know is if you drilled down further into some of the racial and ethnic categories. So, for example, in the Asian group, it's kind of all lumped in. Same with Latinos. But in the Asian category, is that drilled down any further into, say, immigrant status or generational status or class? Because generally, I think the more opportunities, folks that have been here longer or their class status in terms of income might be higher, and they would have more opportunity to get into law school and become an attorney. So my question is, how far have we drilled down?
We don't have information on that level of like family background on attorneys, because that is the only way you can get at it is asking them about their social class growing up. I hear what you're saying, whether they were born in the United States or not, and then further, whether their parents were born in the United States or not. We do not ask that information, that type of demographic information. However, what we did add to the survey a few years ago, and we haven't mined this data yet, but it's on our list of things to do, is that we did add the different ethnic groups under Latinos and Asians. So we are able to make some statements about, like, of everyone who identifies as Latino, what percent identify as Mexican versus Central American, et cetera. And among Asian groups, we have we'll be able to disaggregate that as well.
Yeah, no, I know this is just the start of what you're doing, so I appreciate all the effort and look forward to see how this evolves.
Mm-hmm.
Any other questions?
Comment.
Dolores?
This was an excellent report, very easily to understand. And the numbers speak for themselves.
Thank you.
Yes, thank you for this report. I've been probably very vocal about understanding demographics and kind of parsing these to identify how much further we have to go. So I really appreciate the clarity. And this report is very well done. I think even design-wise, it's very easy to follow. I guess for me, I know we're already midway, but we heard from a very powerful comment today about previously incarcerated populations and what that means to our demographics too. I know that's more technical and detailed, but it's also a really important constituency that I think is seeing much more demand and access and inclusion. And so I know it's probably too late to do it now, but if there's ever an opportunity to do it, I think it'd be very helpful to kind of do a point in time count of where we are there as well in regards to equity.
Okay, thank you.
Thanks.
Okay, thank you, Lisa.
Thank you.
Recent developments. Okay, so then we are going to, as I said earlier, we're going to go into closed session for time to hear reports from our council. Then we'll return back here into the open session. And then consider the remaining closed session items after completing the open session business. For CBE members who are attending via Zoom, please leave this Zoom meeting and join the other Zoom meeting that's for the closed session. And you should have received a link earlier. For the public, We expect to be in the closed session this time for at least 20 minutes. I wish I could give you a more definite time that will return. I always but it'll be at least 20 minutes.
Yeah.
didn't have a chance to make it, but I was thinking I should try to make it.
That would be cool.
December,
if you want to be able to.
Yeah.
Are you meeting here or?
Oh, we got Oh.
So what, are they red sliders? Green, red.
Yeah, oh, okay, on Zoom. Oh, yeah, it's, haven't resumed yet. Oh, I'll tell you, thank you, yeah. And so,
We are back in session. Judge Herman, can you hear us? A thumb up maybe, or that you're muted?
Yes.
Hear you.
Great, thank you. Okay, we're gonna, for the sake of the public members who have been waiting patiently, have their items heard, we're gonna move the agenda around a little bit more. And the first item we are going to consider is 0401. That's action on probation or termination of registration and review of the inspection report for the People's College of Law. In my carryover role as the former chair, or well, still existing chair of the subcommittee on examinations, I'll be presenting this as I did the items last year. People's is a registered unaccredited law school located here in Los Angeles. At our June meeting, this committee issued a notice of non-compliance regarding 18 points of non-compliance with the applicable rules and standards. People's response to the notice came before us in August, where we determined that the response was unsatisfactory and ordered an inspection of the school as required by our unaccredited law school rules. Today, we have the inspection report before us. If we determine that the school, quote, is not or is not likely to be in compliance, that's from the from our rule, we are to notify the school that we are recommending probation or withdrawal of registration. And today, we're not choosing between those two options. We're just simply saying that that's the next step that we plan to consider. The school would then have 15 days to request a hearing, which would be before the full CBE, not a small hearing. Following the hearing, then the CBE would decide to find the school compliant, or to impose probation or termination of registration. So again, deciding whether or not we're going to ultimately recommend or actually take action to put them on probation or terminate their registration, that's not for today. Today, we're moving the process along according to its requirements. Staff's analysis and recommendation is that while some progress is shown regarding various points of noncompliance, full compliance has not yet been demonstrated. And taken together with people's difficulties in maintaining compliance over the past 2 years, which is a history that's described in the staff analysis that I won't go into further unless somebody has a question, and the untested nature of people's proposed future actions, staff recommends that we find the school is not compliant or likely to be compliant, and that we notify the school that the committee recommends probation or termination of registration. Again, that would be followed by, if the staff recommendation were enacted, it would be followed by an opportunity for peoples to file an appeal. And if they did, there would be a full hearing before the full committee of bar examiners, after which then the committee would decide among those three choices I outlined a minute ago: finding compliance, imposing probation, or imposing termination of the registration. So first, I understand this, as I explained quite a while ago now, this morning. Normally, we have 2 representatives from the school speak. We try to limit it. And I understand that the school would like to have 4 people speak. Is that correct?
Yes, and then also, instead of 5 minutes for there to be, we'd be allocated 10.
You can spread your 4 people over 5 minutes?
Over 10 minutes, we'd like to request 10 minutes rather than 5.
Yeah, we can do that. I'll grant you that dispensation. So go ahead and make your presentation. You've heard my summary of the staff recommendations. And then following that, we'll have questions, allow for questions from the committee and a discussion, and then we'll make a decision.
Can I ask a precise question, just so I understood? So if they appeal, is that a separate CBE meeting set just for that purpose?
We'll have to see. We may try, it would be nice if we could say, include that in our December meeting, for instance, but it all depends on what we can schedule. And until we know if they're going to appeal, we really can't schedule it. As I'll mention later, there's another school that has appealed a similar determination, and we're trying to schedule their hearing as well. Requiring the hearing before the full commission, or rather committee, is something I certainly want us to consider changing the rules to make it before a smaller group like we have done for the accredited schools, because it's just so unwieldy to try to get the full committee together for something like that. And it makes the whole process of bringing schools into compliance longer, which isn't necessarily a good thing, but that's for another day to discuss changing those rules. Those are the rules we have. To answer your question?
How long would an appeal take? Is that an hour or 2 hour or 4 hour appeal?
We haven't, we've kicked around the idea of maybe 2 or 3 hours max. Not all day, for sure. But that is something we would have to decide when we schedule it.
Thank you.
So, school, is somebody keeping time?
Yes, Tyler is.
10 minutes, please proceed.
Great. Good afternoon, members of the Committee of Bar Examiners. My name is Edith Pomposo, and I am the new dean at People's College of Law. My career in education spans 4 years. I was a teacher by day while I commuted to law school by night for 4 years. I found that experience quite valuable as I later became an administrator, and most recently have been choosing to develop my career in academic administration. I am duly licensed in the state of California as a public school administrator and a teacher. I hold active licenses in both of those areas. I am well versed in working with accrediting bodies such as WASC and adhering to compliance policies such as special education, having been an assistant principal and implementing individual education plans for our students here in Los Angeles. I also have an extensive amount of experience in working in various schools such as higher ed, Northwest College, where I was the associate dean and I ran 3 campuses, supervising staff, implementing policies, training and developing our teachers, and looking to curricular matters. So with that vast experience, additionally, I am awaiting bar results as I have just completed an LLM from Baylor Law, #2 in the country for litigation. My specialization is in litigation management, and some of the tools that I have learned at Baylor, I'm bringing to PCL to enhance the curriculum, since Baylor Law is the only school in the country that has a litigation management specialty. I think that expertise coming to PCL will really empower our students. Furthermore, in addition to my expertise, I'm also an MBA student at Anderson, the Anderson School of Management down the street at UCLA, in UCLA's business school. So I just wanted to share a little bit of my expertise, and I know I have read and understood the concerns from the State Bar in regards to specifically that the law school hasn't demonstrated it can sustain, to quote, the effort and planning required to proactively prevent issues from happening. I understand that's a viable concern, and that trust has been damaged broken in response to that we haven't demonstrated. PCL hasn't demonstrated that it could properly assess and implement changes needed to succeed. And I'm here to represent PCL, and I urge you, so much of education is working collaboratively. And that's the type of person I am. I work collaboratively. I'm a person that adheres to compliance, rules, policies. That's my nature. That's what I've been doing for years and decades in education. So I was hired a few weeks ago, to be precise. This is my second week on at PCL. So already I have already started to implement measures to make sure that we can rebuild trust with your organization. I've implemented general management tools such as Trello, a calendaring system, and general office procedures to establish and maintain communication, utilizing best management practices, so we don't miss an email, so we collaborate together. So we are calendaring all the deadlines so that we are in compliance on a timely manner with your organization. There was also an issue as to funds not being available because our mission of our tradition at PCL has been to staff our faculty with volunteers. But I don't believe that I wanted to make the the Committee of Bar Examiners aware that currently the board is presently seeking the purchase of an additional building. There is the building that we have has 100% equity in it that the board owns. So what we're looking to do is purchase another building in the same area and use some of the money that is left over from the purchase for the school accounts so that we can further continue to develop our services. And I just wanted to address that because that was one of the concerns of the bar. And furthermore, we have also retained a consultant in higher education to assist with maintaining compliance. And Dr. Collins is available via Zoom. I just wanted to share with the committee some of his credentials. I have his CV if you would like to be made available into record. He holds he's a graduate of NYU in education, then University of Pennsylvania and higher ed administration, and Columbia University, the same an advanced master's in education. To name a few, PhD in education policy, Claremont Graduate University. He's well-rounded and very experienced in higher education. So he's one of my colleagues. When I came on, it was very apparent that we needed a little bit of support. So I recommended Dr. Collins. He can address the board as well. Kevin, are you there? Would you like to say a few things?
Yeah, I am here. PCL is going to compensate me, so I will be doing this with their knowledge. I've been working in higher education for almost the better part of 20 years or so. As soon as Edith shared with me some of the challenges that PCL was facing, I said to her, let's, we can line these up, break them down into 4 or 5 categories. These are relatively easy things to fix. A lot of them are organizational, understaffing, but with if the committee was to give us a couple months, I'm very confident we could turn PCL around, especially because it is such an asset to the community and has been around for a long time. I think that PCL will acknowledge they've made some mistakes, but I think that at this point, with some guidance from myself and Edith, who've worked together for many years as educational consultants, and Edith in K-16 education, I'm confident we'll be able to implement a number of the changes the bar recommended in the letter a couple weeks ago, and if anything, going forward.
And Ira, if you'd like to speak.
It's 3 minutes. I wouldn't say I'd like to. This part of what I'm, thank you. I wouldn't say I'd like to speak. It's a sad part of what we have to say. I'm sad to say, but we need to say it.
You have 2 minutes remaining.
There's some statements, there's parts of the staff report that's given to you today that just are not accurate, in some cases not true, and certainly quite incomplete. I can document a lot of it for you, but I'll just give you a couple examples. There's one part that this is very troubling to us. It says the staff has concern regarding the law school's candor. And it talks about that the bar received complaints from students about not getting transcripts, and the school said, no, they got the transcripts. And, but so says this report, the school didn't tell us that the students might have problems with these transcripts because they were missing grades because the teachers hadn't turned in the grades. What's misleading, I have to say, about this is that we told the state bar in writing that students had not, their teachers had not turned in grades. It's actually one student who complained about the missing grades. And at the student, well, with the cooperation of the student and the state bar, we sent to the state bar this student's transcript. And it shows 4 missing grades with the initials IP, in progress, meaning no grade yet. That should have been in this report, instead of just saying that we were not candid about this issue of transcripts. That should have been in here. That was missing. We
I'm
told
sorry, the
that.
time is up.
I have several more, but my time is up.
Okay, thank you. Any questions for the school representatives?
Yes.
Great.
Thank you. Thank you, Mr. Chair, and thank you guys for being here today. I really appreciated the testimony from your students, and I also appreciate you being here today. I think in the report, you do see there's some concern with compliance. It's followed for 2 years. And so our role as a CBE is, of course, to protect the public, right? What we're hearing is that there's some inconsistencies and there's some items that are of concern. So I guess, do you have a plan to address them? And how are you going to maintain the consistency? Because I think that's the core element here. And me sitting before you, I'm really interested to learn about that, because I think that's what's going to inform my decision.
Sure, absolutely. So I took your non-compliance letter and I divided it into several clusters. Some of those clusters, I came up with about 6 clusters or so. And state and federal law compliance too is academic and administrative policies, personnel, human resources, faculty evaluation, 4, academic integrity, 5, academic support services, and 6, cybersecurity measures. I know that that is a lot to tackle, but that's why we've retained Dr. Collins, who can assist with that. How are we going to maintain that? It's in education, it's all about systems. It's all about calendaring. It's about meeting through with the deadlines and responding to the deadlines and just being proactive rather than the history has been to be reactive with the organization. And that doesn't work well as an administrator. I've trained other administrators and I've trained teachers how to teach, and my long trajectory, I like to have deadlines carefully tailored. And so I think that is a big factor in our success here. Kevin, do you have any additional comments?
The mic was taken away.
Oh,
for
sorry.
Kevin.
Okay, that's okay.
I have one. Part of it is money. We own, school owns, nonprofit corporation owns a building where the school is, about a mile from here or something like that. And it's worth more than $3 million, and it has no mortgage on it. And our plan is to sell that, buy a building in a lesser priced area, because our area is rapidly gentrifying. And we can buy a building, net some money out of it, and a few $100,000, we think. And that will go a long way, because our budget right now is only $125,000.
So there were some items mentioned in the report that I guess our staff was meeting with your team and the dean was not present. So was that you, Mr. Spar? Or?
I'm the lawyer for the school.
Oh, okay.
The dean was, we had an interim dean at the time. He'd only been interim for a few months, and couldn't have spoken to the issues.
Okay.
Edith, our new dean, had not quite been hired. Maybe she was hired like that lead or something like that. So she wasn't in that position.
Okay. See, for me, I think administrators are really key and important institutions. I mean, they guide the organization direction, they develop the staff, they create the timelines, the deadlines. And so I guess the concern from my perspective is that lack of consistency is going to not allow you to be consistent in the scheme of it. What I'm hearing from the public testimony earlier was that they like the rigor, they like the curriculum. The school obviously has an historical legacy. And so for me personally, I'm really interested to see how you come out of this. I mean, right now we have on the table a notice of intent Is it an intent to terminate or is it, or probation, right?
It's a recommendation that we do one or the other,
Okay, okay, so
without
those,
saying which.
okay, so that's what's before us, just to be very clear. It could go either way, I don't know. But if you could speak more to how you're gonna keep it consistent, I think that's gonna really be probably the best foot forward.
May I say something?
Hector is the president of the.
My name is Hector Peña, president of the law school. I'm also a graduate, 2018 graduate of PCL. So here's the difference. We'd never paid a dean before, never. So that's the difference. The difference is now this is a paid salaried job. That's a huge difference. You have a volunteer that is only volunteering on the weekends, maybe in the evenings. It's different than someone working a salaried job. So that's a major, major thing. We have never paid a dean at PCL. So that was also a major expenditure on our part, extending ourselves to want to do that. And I think that our supporters and our alumni recognize that. And we've also received like donations to be able to bolster that decision. And it also pressures us to fundraise for this next year. We have just enough money to cover our dean's position. So I hope that answers your questions. As far as, sustainability.
Mm-hmm. That's ultimately, I guess, where I'm pointing towards. Sustainability is going to be what's important. So we're not back here in 2 years having this conversation, having to come here and defend yourselves as opposed to just continue doing the work that you're doing. Because ultimately, what I would want is for you not to be here and to be doing the work, training your lawyers to be the advocates that they wish to be, right? So that's all I have, Mr. Chair. But thank you.
One thing be short to answer your question. We have a new administrator, started in April, I guess it was. She's here and she was at that video inspection that happened in September. And I think that the State Bar staff will affirm that she has been extremely responsive, whereas the predecessor was the opposite.
Ms. Leonard, did you want to add anything to this discussion?
Maybe just historical context, just for folks. But what's unique about this situation, several things and several aspects. All of the schools are charged with compliance. You have a series of registered schools that have maintained that compliance year in and year out. The challenge that we've seen with People's College of Law is that over 3 inspection cycles, which is literally over a period of 15 years, we've seen the school act responsibly and responsively to sharp directives from the committee. They're maintained for approximately a year. And then when we return for that inspection, we see this again. And so we see the good intentions, we see the energy, we see the passion to create people's attorneys that serve the community. Each point in the face of your directive from the committee, but over a 15-year period, it has not been sustained. Most recently, the school was inspected in 2020. Prior to the inspection, the school was given additional time to have the maximum opportunity to prepare, but there were an enormous number of recommendations. Consistent with the past, the school put forth an absolutely unbelievable effort in early 2020 to make enormous changes. At that time, the council was the dean. In a very small period of time at the beginning of COVID, they implemented a popular e-learning management system. They implemented proper cybersecurity. They began to protect their information. They began a grade calibration. They reviewed their policies and did many other things. This school can marshal energy and has done so. Because of the prior commitment, however, the committee placed conditions on the approval and the registration renewal. Those conditions were that the school would need to show that they could maintain the level that they were at for the next 2 years. And in the first of those 2 years, the school did so. Over the course of the last year, the school was not able to sustain. And so this is the pattern that we've seen over the last 15 years. And here we are at another point where just weeks before coming before this committee, and after a non-compliant inspection, the school is providing another untested situation for you to think about. And so it is exciting and interesting to hear the backgrounds and the plans and the actions in just 2 weeks. But in terms of your duty as regulators, in terms of your respect to the other schools that for 15 years have provided that consistent registration, it's important to understand that context when you think about what to do next. And if anyone has any questions about the time or the history, I think that could be useful. I will affirm what Emeritus Dean Spiro said regarding working with the current administrator, very responsive. Also this year, they implemented a new program for the first year law students exam, and their pass rate, which has been for several years, frankly, 0%, zoomed to 38.5% on the most recent exam. If that's the sort of thing that can be kept, I'm sure that Ms. Dole can tell us 38.5% is well above the average for that exam. If that can be kept, that's very exciting. Over the course of 15 years, we haven't seen the sustenance of that kind of energy. And if there is not a corrective supportive action to the school, query the message that you are sending to other schools that have maintained that 15-year track record at the same time.
Natalie, when you said that they cannot sustain, are you talking about in terms of record keeping, or are we talking about educational performance, just keeping up with these items, or what exactly do you mean?
It's a number of things. Over the course of the last several years, there have been approximately 2 to 3 graduates of the bar licensures for the bar exam in total. Over the last 7 years, there have been approximately 10 licensures total. The first year until most recent was at a 0%. Administratively, things like a catalog that was not current in the main location on the website, though a more updated catalog was sent to all of the students that they had in their possession. Disclosures, the required disclosures that are required under law, not updated after month of reminders from the state bar. And as to the staff requests, there were some staff that are no longer here, but the entire leadership team was being contacted at that entire time. And even with that notice, the questions were not being answered for months or even as much as a year. We've seen much improved response since about Memorial Day, but this is also the time that the committee began the formal disciplinary procedures. And it's consistent with what we've seen from the school before. And so you're challenged at this point. When the school was told that there would be significant scrutiny, they did not deliver, despite spending more time. The State Bar has spent more time working with the school in a supportive manner than any other school that I can remember. And over the course of the school year, when challenged to deliver, they did not. They present a plan now that holds promise, but is completely untested and was created after the non-compliance inspection that addresses the non-compliance before you. So it becomes very challenging to determine what's the right thing from a regulatory perspective.
In your opinion, where they had issues, do you believe that that's from lack of leadership and perhaps the dean himself, or perhaps sitting on his hands and not getting things done?
You know, nothing like that is really ever simple. Over the course of this year, we have not been able to access the interim deans that were in place. And so we question what availability they had for the school. We question what availability they had for the students, and I can't give you more than that. I do think there is a lot of energy for the school. I think there is a lot of love for the mission and a lot of passion for the mission from the students, from the alumni, and from the administrators. I think that they are challenged, and there was an extensive discussion at the time of the inspection that since the 70s, the school has run on largely volunteer labor and passion and love, frankly. But in recent years, we've seen that there is not that level of overall quantity or that level of consistency to maintain institutional knowledge. nor has the school hired people with expertise in running a law school. And this is the first time in the hiring of Dean Pomposo that she does have some experience in the K through 12 sector, some experience as to undergrad, but still not law school. She mentioned that she's taking she took the bar exam this summer, is awaiting results that will be arriving. We wish that they will be successful for her. It may be helpful to know what her experience has been with the bar exam, graduating in 2006 and then choosing to proceed at this time, and what her experience has been and what she will be able to bring. But it is challenging that when the school was challenged to perform, it did not, and it brings you now something untested. So we are where we were 2 years ago and 1 year ago, in which the school has created a plan and promised to perform, but has not delivered. And so it's a question of how to weigh the credibility now.
What are our options? You're talking about there's probation, or the other one is finding of non-compliance. What do those two mean?
Well, probation, termination, or find them to be in compliance.
The termination means they can't be at law school anymore. What is
Right.
probation going to mean?
Probation means we would set the terms, probably require some kinds of progress reports and review their status at another time we set.
But aren't they really in probation right now? I mean, isn't that their current situation?
What I understand is the reason that the committee made the decision it did, looking at the challenges that were before the committee, before the school, almost any other school would have been placed on probation at that time. The school really carried off an unbelievable amount of progress in the period of time that they had. And it's notable that they did so even prior to presenting the report to the committee. They didn't wait for you. They moved immediately, and they made a lot of changes. And as a result, that's why the committee registered. But yes, that 2-year look was clear. What I understand the committee to have expected was that the challenge was understood, the challenge was undertaken in that moment, and the framework would go into place to show that in year 1, yes, it was maintained. In year 2, yes, it was maintained. And now it would be time for an inspection, a deeper dive, where it would be found that, yes, it was maintained. So the level of energy and in fact, the level of execution was as high as what you see today, if not higher. But the school was not able to do so.
So what they're in now is, it may seem like probation, but it's not probation as our rules describe probation. So when we decided, in fact, that they weren't up to the level we expected, then we had to start the compliance process. Whereas if we put them on probation now and came to the end of the period we thought was reasonable for them to raise themselves to the standards we wanted, and we found that they did not, then we could just immediately terminate it. We wouldn't have to go through another whole process of notice of violation, et cetera.
So, Paul, I'm a little confused. I would like to propose the motion, but I want to make sure I understand. Do we recommend probation or withdrawal of registration, or do we choose one of those?
Today,
two
we're
now?
telling them we're going to be considering one of those at a future meeting. I think it would probably be in December. If they don't appeal, it likely be in December. If they do appeal, it might still be in December, depending on, or a hearing whenever we schedule it. I would recommend that if we have a hearing before the full committee, that we combine that with the immediate determination right after the hearing closes of what we want to do, rather than issue a report to ourselves to consider at a future meeting. That just seems like the process that never ends.
So essentially what we're going to say is either they're in compliance, in which case we're done, or they're not in compliance and we're going to go on probation or revoke, and we're going to discuss that at the next meeting. And that's the motion we'll decide on. Now, they'll be aware of the fact that next meeting, we're either going to revoke their license or put them on probation.
Right, and then the clock is ticking for them to decide whether or not they want to appeal and request a hearing before us.
But in the meantime, they're going to be catching up with whatever they need to do. Is that correct? Begin, continue the compliance portion, right?
Yes, I would assume yes.
But I think what staff is saying is that even if they're pretty much in compliance, when we come to our next decision point, that because we've seen this history of oscillation between compliance and out of compliance, that they would probably still recommend probation so we can keep an eye on them for a while to see if they can sustain it. Is that correct?
I have a question for you, Natalie. In looking at their overall plan, and the school is saying that some of the financial instability is what's caused some of the falling back on certain things. So I don't think, at least for me, I'm not questioning the school's legacy or the compassion behind what they're doing. And of course, this school has a great reputation for producing people's lawyers. So is it, in your opinion, is it mainly the money that's an issue? I mean, because you seem to have a issue, a solution to that. Part of it is, tie up with the real estate and what they can do to increase their assets. But is that, from what you see, the major stumbling block? And then I would want to say on top of that, where could the school get administrative assistance? Because I don't think that all of that can come from, the bar, from us. But are there other community partners or other schools that they could possibly turn to get that sort of help on a temporary level in order to get them up to speed on their administrative?
Well, the funding ties with the organizational structure. And so part of the issue has been there has not been an organizational consistency. Organizational learning hasn't been maintained. And so when there is a staff change, as we saw after the first year where the school maintained compliance, the knowledge did not transfer. And the State Bar worked hard to try to bring that about. We had webinars with them, we had reminders, et cetera. But they began at ground zero, selecting new administrators who didn't have that experience, and that experience wasn't preserved in the documents. So I think it's wonderful to hear some of the suggestions of Dean Pomposo today about ways to have a calendaring system, ways to maintain an organizational history. And it's yet to be determined what funding might be available to once the building is sold, if that is indeed the purpose, and if that funding source will be sustainable, but that's also something that could help. I think that probably for many years, in fact, decades, there was sufficient effort through volunteers to maintain the school. In recent years, that hasn't been the case, and maybe it's been a painful realization for the school to accept. But I do think it is that combination of the organizational structure and organizational memory, and the funding could be one part of the solution.
Yeah, well, I mean, financial sustainability is always an issue. And then my experience dealing with nonprofits, a lot of times the mission overtakes the ideas of what it would take to keep, to raise money, to allocate the money in the proper way. It's almost as if the organization needs like a CFO or somebody at that level of theoretical thinking and strategic thinking about how money can get, spent, reinvested, making sure that, those investments are paying off in the long term. Because personally, I'd hate to see the school go down. But then again, as as regulators in this process, I think we need to feel confident that whatever plan they put in place will go forward. It seems like a lot of that is the financial stability of the school.
I would also like to add the past 2 years, we had one of the worst pandemics in our country's history. So I could see where an organization that doesn't have maybe that sustainability, some things are going to break. I mean, every I work for a huge organization that is undergoing some things right now, but obviously not in this position. So if we moved for probation, their disclosure statements would have to be updated, right? are they able to accept students or are they unable to accept students?
You're able to accept students unless you condition otherwise.
Okay, and then my understanding, and I'm looking at this objectively, if I'm someone going to People's College of Law, I'm researching and I'm understanding the institutional background and history. And so in our inspections or anything, have we seen anything that is deceptive or maybe not? 'Cause I know you did say something about disclosure, but I'm just concerned about if that's being presented properly.
Well, two pieces. The first thing is, there's a set of documents called disclosures and they weren't posted.
Okay.
So when they're not posted, it's not to say that it's something being kept covert. They're simply not updated.
Okay.
They were out of date.
Okay.
And are now updated.
Okay.
Most recently, they fell out of date again, but they were this time much more quickly updated. The other piece may just be more complex and we can discuss offline. But the school has had an issue with volunteer faculty not turning in grades on time. And there seems to be some confusion as to the state bar's understanding, but whatever the situation is, their faculty are not turning in grades on time, a significant number of faculty in doctrinal courses. And I think that the administration would like very much for the faculty to disclose the grades, and ultimately they did, but not with the time that the students need. They did take the extra steps, I think in part two, the very responsive new administrator, to make sure that those late grades did not prevent anyone from taking the bar exam who wanted to do so. But it is an issue. It's a very basic thing, especially when a school is under that type of spotlight to show that they can perform when the school cannot deliver grades. That's of great concern.
Yeah. I guess my train of thought is one of our buffers is the first year law exam, right? And so you mentioned that they went from 0 to 38% within the last year, or is it?
It's just this one exam.
It's this
So
one
for
exam.
a period of time, it was quite different. But what was
Okay.
different about this exam, and I believe that President Peña could tell us more, they have involved a consultant that was specifically focused on the first year law students exam.
Okay.
And I believe they also are now becoming involved in the TORCS program at the school as well. Is that correct?
Yeah, I mean, we've done a lot, actually. We hired someone to come in and do the mock exams. The person is more of a student resource coordinator. So they would conduct the mock exams, they would grade essays, pretty much have mocks, full-length mocks. Person is paid. And then we also paid for Adaptive Bar. We paid for an institutional license, which was very expensive. And then at the end of the day, I mean, a lot of students passed the baby bar, right? So it showed that that investing money in educational, resources for the students pays off. So we decided to do that. So we have Adaptive Bar, and then we're paying someone to come in to conduct the mock exams and grade essays.
We're talking about the LA campus, correct? Only?
It's a single campus school.
Okay.
And I believe that consultant is still working with you this year.
Yeah, sitting right there.
Any more discussion or questions?
I'm ready to make a motion.
Dr. Wilcox
Yeah, that's right. I'm
has his
sorry.
hand raised.
Oh, okay. I don't see him.
He was part of the inspection.
Oh, okay.
Dr. Wilcoxon, go ahead.
Thank you. Thank you very much, Mr. Chair. I just want to, I'm in agreement with everything that Ms. Leonard said. One of my concerns is the ability of the law school to demonstrate that they will break this cycle of response and inattention. That's one of my main concerns. They have the energy, as Ms. Leonard said, to improve on the recommendations that we give them right away. They showed that in 2020, improved record keeping, installed the computer system, improved test security, improved policies and updated documents. But then now, or 2021, 2022, things kind of slipped. Now, while the original recommendations for 2020 inspection were addressed, there's several that need to be readdressed, as has been mentioned. Disclosures, clear communication, course grades, grade review, sufficient staffing, faculty evaluation, attendance, grade policy, academic achievement, and transcript policy. All that said, I would like to ask staff to fashion terms of probation to consider at our next meeting.
Second that.
Well, yeah, motion first.
I think so. Was that a motion?
You want to read the motion?
Let's suggest you incorporate
Oh.
that
Yeah,
into the main motion. Can somebody put the motion on the screen? Natalie, is it fair to say that you would be proposing terms of probation as part of the next steps in any event?
Yes.
Okay, so is that satisfactory that that's part of the normal process?
Yep.
Will that be satisfactory to Dr. Wilcoxon?
Dr. Wilcoxon, does that cover your concern?
Yes, ma'am.
Okay, thank you. So does somebody want to make the motion? Did I hear it?
If he didn't make it, I'll make it.
Okay, so motion, Mr. Gongora. Do we have a second?
I'll second.
Second, Mr. Reyes. Roll call vote.
Dr. Bolton,
Yeah, yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
yes.
Jim Epstein.
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Larry Kaplan,
Note for the record that he recused himself.
Alex Lawrence, Esther Lynn, Bethany Peak, Vince Reyes,
Yes.
David Torres.
Yes.
Dr. Wilcoxon,
Yes.
the motion passes.
Okay, thank you. We have one more school item so that we can free them for their days, what remains. And that is 0402.
Mr. Chair, could we, what does that message mean? I guess since we have people here.
Did you have a question about what?
Like next steps?
Well, next steps would be for the school to decide whether or not they want to appeal.
Okay.
And if they do, then we will need to schedule a hearing for the full committee. When that would be is, we can't predict today. If they don't appeal, then I presume the item would come back to us in December.
Okay.
To make that official decision about what we want to do.
Thank you, Mr. Chair.
Thank you.
Have a good rest of your day.
Thank you.
Take care.
Thank you all for coming and indulging our schedule.
Thank you.
Thank you.
So the next item is 0402, that's action on a major change. Central National University to change the school's name and to acquiesce in the law school's non-JD programs. This accredited law school seeks our approval of its merger with National University and name change to the JFK School of Law at National University and our acquiescence to its non-JD programs. And they're also because they did not file this application more than 180 days before they wanted to take effect, for us to allow expedited consideration to allow the changes to take place on November 1st of this year, less than a month from now. JFK has been affiliated with the National University System since 2009. The staff analysis gives more details about the journey it has taken from an independent school to the now proposed merger into National University. Staff recommends approval of the request, including the request for expedited consideration, but wants us to be clear in general to schools that we expect them to file the request in the time required under the rules, so that, in other words, the 180 days that I just mentioned, so that there's sufficient time for staff to perform its analysis because, this is the only thing on their plate. But also to work out any details that require, say, additional information from the school. Or maybe even the committee might have some issues that need to be worked out. In other words, wait to the last minute at your peril, because, a snag might upend your plans. In this case, I guess if the staff recommendation is approved, it would not upend their plans to merge by November 1st. But there is that precautionary note that I don't know if it'll be heard anywhere, but there I stand. Do we have a representative from the school who wishes to comment or be available for questions?
We do have the dean, Lisa Hutton, as well as a representative from National University for Receiving School, Mr. Joe
Are they
Cicero.
with us? Or,
They are via Zoom.
okay, they're on Zoom apparently, so Devin, could you activate their?
Hutton and Cicero, please.
Hi, am I unmuted?
Yes.
Can you hear me? Okay, thank you to the committee. This is Lisa Hutton. I'm the, Dean of the JFK School of Law, currently at North Central University. And as the chair pointed out, JFK School of Law was a brick and mortar institution accredited fully by the Committee of Bar Examiners since 1981. In 2020, the system decided to merge and go from 3 degree awarding institutions, which was John F. Kennedy University, North Central University, and National University, into 2. So the JFK School of Law was absorbed, or I call it adopted by North Central University, and this was approved by the committee. Since that time, the Board of Trustees has voted to go from 2 degree awarding institutions down to 1, and the resulting institution, and so the merger of NCU and NU, the name will become National University. So that is what is on the docket today. I want to say that I've heard Mr. Kramer's comment about the 180-day rule, fully understand that. Please accept our apologies. It's been quite a process with the Department of Ed and WASC and delay after delay with respect to when to notify the committee. The moment we seem to have a thumbs up to be on WASC's agenda, I did notify Ms. Leonard, have been in contact with her. Our initial application was filed, or major change, was filed thereafter, I believe it was June 24th. But on July 7th, we met with Ms. Leonard, and she indicated we needed to do a request for acquiescence for our undergraduate paralegal programs. And that was unknown to me, given that it isn't a degree leading to professional license or law degree. But so we pulled it and filed the request for acquiescence as well as this waiver as soon as we could. So I appreciate the committee's time, and I want you to know that your statement, Mr. Kramer, has been heard, and it's very fair.
Thank you. Does anyone have any questions for the school? Any discussion or a motion?
So moved.
Second.
Okay, can we put the motion on the screen? Okay, who was the maker of the motion? Did you get the name?
Yes, I did.
Okay, let's take a roll call then.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cal?
Yes.
Alex Chan? Jim Epting?
Yes.
Kareem Gangora?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence? Esther Lynn? Bethany Peak? Vince Reyes?
Yes.
David Torres?
Yes.
Dr. Wilcoxon?
Yes.
The motion passes.
Okay, thank you.
Sorry, can you confirm the second? Do you have the second?
It was by Kareem.
Oh, yeah.
Okay, so now we're going to go back to where, Amy, correct me, I believe we were in the start of examinations.
Yes.
So we're going back to item 0200. Discussion of the Blue Ribbon Commission on the future of the bar exam, recommendations and next steps. And as you noted from the report that was attached to the agenda, this is very much a fluid item. And since that came out, the Blue Ribbon Commission met yesterday. And as I understand it from Alex, he feels that we can postpone this discussion until our December meeting. Is that right? He says yes. Okay, so we're gonna, I don't know if table is the right term, but anyway, we're gonna move that to our next agenda.
Do you need a motion? No?
And then, in the interests of our time, this was the one we took.
Yes.
The 0201, the technical report on the June 2022 first-year students law students exam, we can also push to our next meeting. If we end up at the end of the day having time, we could bring some of these back. Well, no. That makes people confused. We'll just talk about that in December as well. So the next item is action on revisions to the testing accommodation rules. A recommendation to circulate them for public comment. It's item 0202. And Lena, do you want to lead it off, or who's going to be Christina?
Okay, so I will be presenting agenda item 202, which includes 5 attachments for the committee's review regarding the ongoing plan for the State Bar to revise and streamline the testing accommodations process. State Bar is engaging in a review and evaluation of not only the admissions rules, but policies and procedures followed by staff. A review of the testing accommodation forms and application process as a whole has led us to the discussion today. The State Bar has held 2 testing accommodation stakeholder forums, as mentioned by the public comments earlier today. We received written comments. We heard verbally from individuals on their past and present experience with the testing accommodations process. Applicants voiced concerns about the amount of time it took for final decisions to be reached. They voiced their frustration over the number of documents required, the cost incurred seeing assorted physicians, all of this while taking time away when they should be studying for the exam. The proposed framework, TA framework in this agenda item is intended to address some of those problems. At the most recent forum, which was held just last month, we received comments and feedback on the drafted framework. The framework is included as agenda attachment number C. It strives for transparency, consistency, and a streamlined review process for our testing accommodations. The framework for the enhanced process that staff is proposing is derived from the Department of the DOJ guidelines for testing accommodations, as well as the consent decree entered in the Department of Fair Employment and Housing versus the Law School Admission Council. The streamlined process relies on proof of past accommodations received on high stakes exams. It gives weight to the applicant's qualified professional, and it limits the documentation request to those that are narrowly tailored. Applicants may choose to go through this streamlined new process, which grants the same or lesser past accommodations if the applicant has taken the first year exam, the bar exam, or the MPRE. If an applicant hasn't taken or hasn't been approved or denied accommodations on any of those 3 exams, they can still choose to go through a streamlined process to request the same past accommodations granted from either another state bar or other high stakes exams like the LSAT, the GRE, the GMAT, the MCAT, the SAT, the ACT, or the GED. The request for past testing accommodations will be sent through a simplified process in which the accommodations were approved, if the accommodations were approved in the last 5 years, that the applicant submits proof of the past testing accommodation and that they certify that they're experiencing the same functional limitations. There are some conditions placed on the approval of past accommodations. For example, accommodations for more than 50% time or accommodations for a private room. The applicant would need to submit additional documentation in support of those two requests. If the applicant is requesting greater or additional testing accommodations than previously granted, the applicant must also submit documentation tailored to support that accommodation. The State Bar also is identifying a standard set of accommodations for those with certain temporary health conditions, such as pregnancy, for which an individual may not likely have a prior recent history of past accommodations. The updated process is expected to reduce time between an individual submitting a request and a decision on the request. Additionally, rather than submitting multiple testing accommodations, currently the State Bar has 8 testing accommodations forms for the applicants to fill out. In your proposal, you will see the streamlined process has only 2 forms, the TA request form and the qualified professional certification form. Those are labeled as attachments D and E on your agenda item respectively. The TA request form is shown in hard copy form on the PDF on the agenda, but that would actually be an embedded electronic form through the applicant portal, which is what applicants use to apply for testing accommodations already. The form requests background information on the applicant, their disability, and documentation on previous past accommodations granted on high stakes exams, if any. The qualified professional certification form is designed to solicit information that is limited and narrowly tailored to determine an applicant's disability-related functional limitations and their access needs. A few of the substantial changes in the rule proposal, those would be labeled as attachments A and B in your agenda item. Includes a recommendation that the State Bar contract with a disability accommodations expert to review accommodations request. Any denial or partial approval for an accommodation would be accompanied by a report from the expert explaining the reasons for the decision. And if a request is not granted or granted with modifications, a second and different accommodations expert would review the request. This alters the current process of handling request for review by substituting a disability accommodations expert for the role of what the committee does currently. Committee oversight would still remain in the rules to ensure staff is carrying out the process consistent with the rules and the framework as posted. The agenda item proposes revisions to the TA rules to clarify and streamline the application and file review process and requests the committee to recommend to the board to circulate the rules for a 60-day public comments period.
Thank you, Christina.
Thank you.
Thank you, Christina, for a very thorough overview of that. I'm going to be supporting the staff recommendation, but I want to say to my fellow CBE members, I'm very pleased to see that the bar is very responsive to us CBE members and what we bring to the table. This is the second time I've worked with staff on something. David Torres and I worked on extending the 5-year rule with Donna, and Dr. Cal and I work with Donna and Christina on the proposal that we have now about testing accommodations. And I hope everybody on the CBE gets a chance to have a project with staff and that you have a similar experience. It's no rubber stamp. I found the staff members to be very responsive. Paul got involved in a subsequent meeting on this, and staff was all ears to what we had to say, and many of our comments were incorporated into what is before us now. So let me just, Christina did a good job, but I'm just going to summarize what I think are the highlights of this proposal that I think is going to be great for applicants. Number one, simplicity. The idea here is to streamline the process for applicants who are requesting an accommodation. Number two, expediency. The decisions on an application can be made faster under this process rather than the delay of the next CBE meeting. Number three, consistency. And I think this is what I value the most about this, because I'm going to be the first one to admit that is not my area of expertise. What we are trying to ensure, what the bar is trying to ensure, is that like applications are handled in a similar way so that everyone is treated fairly. And number four, and I guess the final thing, is that to ensure that the bar is going to be using independent experts in testing accommodation review. So you're going to have a process where your application is going to be reviewed by an expert, she or he, with expertise in testing accommodations, with a right of review, if you request it, by a second independent expert, independent of the bar. So the oversight by the CBE, because we're going to be, we're in this at the beginning, and now the end has yet to be determined. But I think we, Committee of Bar Examiner members, can comfortably adopt this motion with the idea that Donna and Paul are going, and all of us are going to fashion a proper oversight for what we see at the end. Maybe trends, maybe number of applicants. Right now, it's 10% of our applicants. That's 1,000 applicants for the summer bar requesting accommodations. That's quite a lot. And I think that this proposal is going to go a long way in streamlining this for applicants. I do not believe that this process is meant to serve the bar staff. I truly believe it is meant to serve the applicants in an expedient way. So, does anybody else have any comments?
Before we have any more discussion, we had promised that we would take public comment on each of these rules. So, Devin, can you see if you want to make a public comment on this and you're on Zoom, you either press the button at the middle bottom of your computer screen or press star and then 9 on your telephone to raise your hand. Any of the two people in the room where you're not commenting on this one? Okay, thank you. Do we have anyone wishing to make a public comment?
We have one member of the public that wishes to make a comment.
Who's that?
Charlene.
Did that person comment before?
She did earlier today, yes.
And I'm sure she commented about this, correct?
I believe so.
Okay, so that would be double dipping, which we weren't allowing. So we've already heard her comment. And nobody else?
No.
Okay, then we can close public comment. I wanted to propose, well, let's see, Larry, did you want to say?
Yeah, I just had a question. Robbie said, what, 10%? 10% of the people ask for accommodations, testing accommodations? Is that?
Christina, is that correct?
That's my general understanding for the summer bar. 10%, or actually.
Is that like crazy off, or is that sound?
No, that's close. I don't have a number right in front of me, but particularly this July bar, we saw a huge spike in our requests.
So in other words, that's a spike. It's not
historically
Well, each year it does generally
So there's an upward
increase.
There's a,
upward trend.
Yes,
It's interesting.
and it has been for many, multiple
Do people
years.
know what, do you know why, or?
and it's not just with the state bar. I think it's a phenomenon that's happening in other jurisdictions as well.
Yeah, I think you see it in schools too, where more students are, having things like ADHD. And I guess just a societal
Or
thing.
discovering it.
Yes, societal thing. Interesting.
Okay, could somebody put up 4.93, that's the section on the committee oversight on the screen?
I can, just let me find it real quick. I have a bunch of tabs open. You are requesting on the rules, correct?
Yeah, I wanted to express my opinion that we should delete the second sentence of that section.
In section A or?
4.93 there, so the sentence said, scroll up for the comment, the caption.
The one that starts, the committee shall periodically receive written reports, that sentence?
I think we're at a point where we haven't, as you alluded to, Robbie, we haven't figured out exactly how we want to undertake this oversight activity. And while this language is broader than an earlier draft, it still doesn't cover the universe of possible methodologies that I know of. And so I don't want to limit our ability to design the best solution for us by having this language in the rule.
Okay, I mean, given that that's a work in progress and a necessary one, and the staff is in agreement, and Larry, your comment kind of hits home why we, as a committee of bar examiners, need to stay on top of this. That is a huge number. That's 1,000 applicants. Now, many of those requests are easy. I need to stand and stretch. I want to bring a chair. I need a lectern. Those things all get granted. And the last row of the main place where the bar exam is given accommodates those kinds of things easily. But still, it's huge. It's a huge number. So this goes a long way. And I have no problem making the motion with the understanding that that sentence be removed from the language, if that's okay with you, Donna.
One, I have no vote. Two, I completely understand where the committee is going, and we have every intention of fashioning the right oversight process to ensure that the committee has oversight. I feel certain that included within whatever we fashion will be something where staff will be presenting what we've observed as trends that we want to bring to your attention. That may be part of what is done and not the whole thing. So I don't think this reduces the amount of oversight, and I don't think it ties our hands for fashioning the best oversight to make sure the committee is doing is engaging its responsibilities.
Okay, any more discussion, or are we ready for a motion?
Then I'll make the motion.
Can we get it up there?
I will second that motion.
Dr. Bolton?
Can I get some clarification? Sorry. So is the motion is written here, or is the motion going to add a paragraph that we approve, what is the attachment A with the following deletion?
You can say as amended.
I could, yeah, attachment A as amended for a 60-day public comment period.
But you don't have amended how you're going to amend it in the motion. The motion has to say how you're amending it.
Yeah, so we can say, so Devin, in the second to last line, after it says of the rules of the state bar, comma,
Deleting the second sentence in Rule 4.93.
and right before deleting, I'd say with an amendment, or actually as amended, deleting, as amended,
deleting this, there you go. I think that does it.
But you don't mention Exhibit A in there now, or Attachment A.
That is
4.93 is just part of A. You're saying we're adopting all of A except that one paragraph. So don't you have to mention Attachment A in this motion?
Either way, it reflects the proposed revisions to the Chapter 7 rules
Okay.
of the State Bar.
Long as-
You can say included in Attachment A as amended. That works just as well.
As long as everyone else is comfortable, that's fine.
Yeah, I think there are two ways of describing the same thing.
Okay. So we have a motion and a second, right?
Okay. Do you have the names?
Yes.
Okay, I guess we're ready for a roll call.
Okay, Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epstein,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak, Vince Reyes,
Yes.
David Torres, and Dr. Wilcoxon.
Yes.
Motion passes.
Okay. Just a minute. Are we ready for another break or keep going? Okay. 5 minutes good enough? Okay, 5 minute break.
We have quorum separated.
Good discussion.
I think so.
Here we are, having a 5-minute break.
I think we're going to form to start with the whole meeting. aren't we?
Yeah, so we're gonna cut a few things that can wait until next time, in order to move the meeting along and allow us to meet some commitments we have to airlines and others. So, for instance, we're gonna move discussion of the goals for each of the subcommittees to the December meeting. And then our next item we will consider is 0300. That's action on the recommendation to adopt a rule change eliminating the 5-year period of validity for passing bar exam scores. This is on a return from public comment. Donna?
Thank you. So today I'm bringing back to you all for approval following, following public comment, proposed rule changes eliminating the 5-year limit on the validity of the passing bar exam score. As a reminder, current State Bar Rule 4.17.
Chair, like, too long.
Okay.
Yeah.
Current State Bar Rule 4.17 provides that within 5 years from the last day of the bar exam on which an applicant received a passing score, the applicant needs to meet all requirements for certification to the Supreme Court, such as positive moral character determination, Cassian-Geary score, and they must, within that 5-year period, take the attorney's oath. Following our highlighting this topic at your meeting in June, committee members Robbie Brody and David Torres volunteered to assist me in exploring changes to this rule. At your August meeting, we presented a proposal to eliminate the 5-year timeline, having concluded that it does not serve, it served to further public protection, and it created an unnecessary barrier to admission to the bar. Following your recommendation, the Board of Trustees approved circulating the proposal for a 45-day public comment period. During that public comment period, we received 17 public comments. They are set forth verbatim in the comment chart that's included as attachment A to this agenda item. Of those 17, 10 agree with the proposal as drafted, 5 agree if modified, 1 disagreed, and 1 was unrelated to the subject of the proposal. In addition to the public comment chart that is included as attachment A, the agenda item itself discusses the suggestions of those who asked for modifications to the proposed rule and the 1 individual who expressed disagreement with the proposed rule. As you will see in the agenda item and in the response column on the public comment chart, staff does not believe that any changes should be made to the rules in response to the comments received. I would be happy to discuss the response to any or all of the comments or address any other questions you may have, but I don't want to I trust that you all have read the agenda item. So I'll take any questions that you may have about the proposal or the comments, and then would ask for a motion to recommend to the Board of Trustees adoption of the rule revisions that are included in this agenda item.
Before we do that, let's check for public comment. Is that Jessica Park? Hi. Yeah, you look different. Did you have any comments on this item? Okay, anyone on Zoom?
We do not.
Again, just raise your hand, pressing the button at the bottom middle, or you press *9 on your telephone.
No public comments.
Okay, no public comments. Any questions or discussion?
My position hasn't changed or gotten any stronger. I'm going to vote no. We can go.
I don't vote, but I would do that as well. Great.
Retroactive application, what is that gonna look like, Donna?
Now you're making me remember
I'm
that
so
further.
sorry.
So what we had proposed was that anybody whose 5-year period expired, so if anybody who took the July 5th, 2015 bar exam, their 5-year period would have expired July 2020 during the pandemic. And so anybody who took an exam prior to July 2015, their 5-year period would have expired prior to the pandemic. So we were using the pandemic as a timeline to say, anybody whose 5-year exam would have expired during the pandemic or subsequent to the pandemic would, this rule would be retroactive to them. So if your bar, if your passing score expired July 2020 or subsequent to that, then you would be either recertified to the Supreme Court, or you would not have to take another bar exam, or you would be allowed to continue to. Some people may not have been certified to the Supreme Court, and so they still need to proceed to get moral character, et cetera. But that's how far we would go back, and that was the rationale for picking July 2015.
So you could wait another 20 years or more and decide that to become.
Yes. Yes.
Well,
Well,
I think I better make a oh, go ahead.
yeah, I was gonna say, of course, it's no secret that I am in support of this, and I will be voting to support this for the simple fact that I feel, in my personal opinion, it was an arbitrary rule. I understand others may disagree, and I totally respect that. We heard even in the comments that someone said this specifically, it's arbitrary rule. Who came up with 5 years? Like, that's exactly what one of our public commenters stated. So thank you for your work on this. Thank you, Robbie. Thank you. I know my friend, Mr. Torres, is not here to discuss this, but he was very happy about the direction it took. So thank you.
Yeah, may I ask Jim to say a little bit more about your vote?
Well, so it may be an arbitrary number, but we live by arbitrary numbers all the time. We have 30-day, 60-day, 120-day statute of limitations. Attorneys are expected to comply with them. And I think it's important to have a rule and people be required to follow it. If you said, maybe 6 years instead of 5 years, I might be willing to talk about time, but you have an unlimited, as you said, 20 years, 30 years. I just think you have to have rules and people should follow them. And so that's why I want to keep a rule that says 5 years.
Paul, can I make just a short comment? I remember when we discussed this originally, there were some very thoughtful comments, both by Jim and by Dolores. I remember distinctly, and of course, I've been around a while when we've had these 5-year cases come up before us. Many of them are compelling cases that resulted in quite a lot of discussion, whether it was a military spouse, someone who immediately got, I think, Jim, that when we think about this, oh, come on, it's the most nothing thing that you have to do. You've done everything else. You've passed the bar exam, you've got your moral character. Why not comply with a simple time requirement? Well, one, it's super rare. I think we're talking about less than a dozen in a given year, or less than that, maybe less than half a dozen. And the ones that have come before us generally have had a reason. They immediately went to work in another state. They did not want to be saddled with $500 a year in dues. And what we learned was there's no practical reason to require it. There's no continuing education requirement for someone that goes inactive. So it was kind of like, given how few there are and given how compelling some of the reasons that we hear are, military spouse, another career, practicing law in another state, what is the reason to require it when you can pass the bar and go inactive and have the same lack of continuing education requirements, although you still have a fee to maintain your inactive status? So I think when David Torres and I looked at this with fresh eyes when Donna proposed it, we decided, you definitely should have rules that you must follow, but why have this rule? Why put this one on our bar passers? So if we don't have this rule, then you're not violating it. You're going to have an opportunity to do what everybody else does when you are ready to do it. And remember, of course, if you don't do it, you can't practice law in this state. So we're not giving anybody an edge on an ability to, if public protection is our overreaching goal, which it is, I don't think we deviate from that in any way by allowing those very few successful applicants who pass the bar to delay their admission and their ability to practice law in this state, which is why David, and I think I'm going to speak for David because he and I were both supportive of removing this from one of the rules for successful applicants. And I will make the motion if there are no more.
Got Larry.
Oh, I'm sorry.
Yeah, so that's a question. What's the concern or is there concern over loss of professional knowledge because they're not doing CCE and, you know, they took the bar exam and let's go take the extreme, 10 years. Okay? A lot of stuff changes. Okay, so somebody who took the bar 10 years ago, is there concern over, you know, they've like kind of lost it or something? And also changes in moral character. You know, they passed moral character and then like, you know, they did some nasty stuff. But we don't know because moral character was earlier.
Yeah, so great questions. The original agenda item, when we talked about this in August, laid out some scenarios that were comparing, in answer to your first question about what are they losing? Are they losing minimum competence, right? So we laid out some scenarios where we've got these folks who pass the bar, therefore demonstrating, right, that they possess the minimum competence. And then they don't get sworn in for a variety of reasons that were laid out in the scenarios, and they want to get sworn in 6 years later. Okay, so take me as an example. I was sworn into the bar more years ago than I care to admit at this point, almost 30 years ago. I've been taking continuing legal education because I'm active. Tomorrow, theoretically, I could put out a shingle and say I am practicing in a variety of fields. Now, I have a duty of competence that I am subject to, but I've never set foot in a courtroom in 30 years. The question is, or let's imagine I went inactive. I passed the bar and I went inactive. I had no continuing legal education requirements for the last 30 years. None. In what ways am I different than the individual who passed the bar and didn't get sworn in? Only that I got sworn in and I'm paying my inactive fees, and payment of fees is certainly not a reason to make that distinction. Now, some will argue, yeah, I don't think it's right that the people who've been inactive shouldn't be retested. But we have no requirement if you're inactive that you catch up on those CLEs. You don't have to take another bar exam. There seemed to be a real inconsistency in how we were treating those who passed the bar and didn't get sworn in, and those who passed the bar but did get sworn in, when they may be in the exact same place in terms of establishing minimum competence at one point and what have they done since in that field. On the moral character point, and thank you for reminding me of this point. So there are two possible populations that we're dealing with here. The one is the people who passed the bar exam and immediately got certified to the Supreme Court, or put on the motion, as we say, because they've met all of the other requirements. What's going to happen under the new proposal is after 5 years, they're going to get decertified and they're going to have to renew their moral character. So they will submit an extension application to Tara and her team for that period of time since it last expired. And we will have to do that moral character determination. Now, everybody remains under an obligation until they get sworn into the bar to keep us apprised, but this will give us that extra look because they will be decertified. They have to get an extension of that positive determination, and then they can be recertified to the court. For the other population, i.e. the people who passed the bar exam but haven't yet met other requirements, mostly that other requirement is going to be they don't have yet other positive moral character determination, right? So their determination, because they haven't been certified at Supreme Court, if they have a positive determination, it only lasts 3 years, and then they'll have to get it renewed again. So I think
I feel like we were very thoughtful in making sure that there wasn't that moral character risk and that that's built into this process.
Makes
And
sense.
again, my argument, I think I made this before too, was that the error of our ways with respect to inactive attorneys does not justify making a second error with respect to people who don't license on time. I think the better choice would be dealing with inactive attorneys and doing something to correct that problem, because I think that's a problem also. So that's just my position. I understand your logic, I just have a different logic.
No worries. Thank you. I'll make the motion to adopt or approve staff's recommendation.
Second.
Roll call.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan? Jim Epting?
No?
Kareem Gangora?
Yes.
Dolores Heisinger?
No.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence? Esther Lynn? Bethany Peak? Vince Reyes?
Yes.
David Torres? Dr. Wilcoxon? The motion passes.
Okay.
What's a quorum? Do we have a quorum? What's the?
Barely.
We do.
I think we can lose maybe one more unless somebody left since I last.
Nobody leave.
Okay, the next is another rule package action on revisions to the practical training of law students rules, recommendation to circulate for public comment, attachment 0301. Who's presenting that? Kathy?
So she's going to be on Zoom. She's being promoted now.
Kathy, you've been promoted.
Yes, thank you. Good afternoon. So as you may recall from the meeting back in August, I've been working on the piece of the rules revision project that deals with two programs, the Practical Training for Law Students, or PTLS program, excuse me, and the Law Office Study, or LOS program. At that August meeting, David Torres and Larry Kaplan volunteered to work on this project, and they have been working with staff to identify some needed changes, resulting in the package that is before you today. The package includes several significant substantive changes to those two programs, in addition to some more technical changes to improve the administration of the programs. The specific proposed changes to the rules and one proposed pandemic grace policy are in attachments A through E to the agenda item. Just to give a little bit of background on the two programs, the PTLS program is the program that allows law students to get practical experience while they're still studying law by permitting them to negotiate and appear on behalf of clients under certain prescribed circumstances, and always under the close supervision of a supervising attorney. The Law Office Study program is an alternative pathway to licensure that allows individuals who complete 4 years of study in a law office or judge's chambers to sit for the bar exam. With regard to these two programs in particular, one reason that we've been looking at changes to the rules is that the California Supreme Court has ordered us to consider certain changes. Specifically, last fall, the court ordered the state bar to consider whether LOS students should be allowed to participate in the PTLS program. As part of the broader project of rules revisions, we've also been taking a more general look at the rules for these programs to identify rules that might create barriers to participation when whatever the rule is not necessary for public protection. There's 4 substantive changes in the rules proposals and the proposed policy that are before you today that I'm going to outline those changes, and then I'll give a little bit more detail about each one. First, the proposed changes would, in accordance with the order from the Supreme Court, it takes the position that we should allow law office study students and also students in Master of Laws or LLM programs, who are typically students who got a legal education abroad and then do a year in the LLM program before taking the bar, would allow those two categories of students to participate in the PTLS program. Second, they eliminate the current requirement that to participate in the PTLS program, a student must have completed or be currently enrolled in courses in evidence and civil procedure. Third, it would make changes to requirements for the law office study program to recognize some of the ways that the practice of law has changed, and specifically to allow those students to complete their studies remotely while retaining a requirement for a minimum level of in-person supervision of the law office study students. And then finally, recognizing the impact that the pandemic has had on all of us, including LOS students, the package includes a policy that creates a 60-day grace period for students in the LOS program to submit up to 2 of their required 6-month reports, where for what they submitted those reports late and had them rejected, or they missed those reports during the period of the pandemic. So for a period of 60 days from when the policy, if the policy is enacted, those LOS students would be able to submit 1 or 2 reports covering their studies during 6-month periods that have happened since the start of the pandemic. So let me go in a little bit more into detail, but I will try and keep it as brief as I can. As I mentioned, the issue of allowing LOS students to participate in PTLS was put before us by the California Supreme Court. It also comes up every year in inquiries to staff. The ability to participate in that program is really highly valued because I think students understand the importance to their legal training of getting that kind of hands-on experience. So there are a lot of students, or there are some students at least in the LOS program and some in LLM programs who are eager to participate in the PTLS program. Although there's nothing in the rules right now that expressly bars those students from participating, some of the requirements for applying to the PTLS program, in the case of LOS students, that the requirement that they submit a declaration from a law school official, and for LLM students, the requirement that they already have completed a full year of study, those requirements essentially make it impossible for those students to apply to and participate in the PTLS program. As David and Larry worked with staff to look at whether LOS students and LLM students could participate in the PTLS program while still maintaining public protection for the clients of those students, I think we all recognize that the kind of experience students get in the PTLS program significantly benefits their learning and eventually helps them become better lawyers. So students in the LOS program or who are in LLM programs should also be able to get that benefit, so long as they can do so without putting their clients at risk. And there doesn't really seem to be any reason to think that those clients would be more at risk than the clients of students in traditional JD programs who participate in PTLS. They would be just as closely supervised by the supervising attorneys, and they would be subject to all of the same restrictions as to the scope of their activities. The changes to the rules themselves are straightforward. They just created a new definition of law student to expressly include students in the LOS program and LLM students. And then they set out the particular requirements for them to be part of the PTLS program, where the requirements that are applicable to JD students don't make sense. With these few changes, we can open up the PTLS program to more students and give them the work experience that down the line will help make them into better attorneys. The second major change to the PTLS program proposed in these rules revisions is the elimination of the requirement that students participating in the program have taken or be currently enrolled in courses in evidence and civil procedure. All 50 states have programs that are similar to the PTLS program that allow a kind of limited scope of practice by law students under supervision. But California is unusual in requiring students to have taken coursework in those 2 specific areas. Most states just have requirements as to how many semesters a law student must have completed, but not for specific coursework. In addition, even in California, we know that students participate in PTLS when they have just begun to take these courses. So, it's your first day of taking evidence and civil procedure, and at the same time, there you are participating in the PTLS program. But those students are just as successful as the ones who have already taken the courses and have completed them. So we believe that removing that requirement for the courses would remove an unnecessary barrier. And again, give more students the opportunity for this really valuable type of experience that they get in the PTLS program. So then moving on to the changes that are, sorry, did someone? I thought I heard someone. Moving on to the changes for the LOS program, we found in looking at those rules that they really seem to be based on an outdated model of what legal practice is like. So they require, for example, that student study take place, quote, during regular business hours, unquote. So the proposed changes are updates to the rules to allow the student and their supervisor to determine the hours of study that make sense for that student, as makes sense, because this is really, LOS provides a very individualized educational experience. And then the changes also expressly allow for the student to complete some or even most of their studies remotely, allowing even the required weekly one-on-one supervision hours to take place by remote video connection. However, recognizing that Zoom calls are never quite the full equivalent of in-person meetings, the changes have been drafted to require that at least 5 hours of supervision for each 3 months of study take place in person. Again, so the hope is that these changes will open up the program so that more individuals would be able to both participate and succeed in completing the program, and down the line, again, succeed as attorneys. In addition to the changes for the rules for the LOS program, there is a proposed policy, attachment E to the agenda item, to allow a grace period for LOS students to submit reports on their studies that were missed or late during the pandemic. The existing rule requirement that moving forward is unchanged, is for a student in the LOS program to submit a report every 6 months that details what they've been studying during those 6 months. They attach their exams to that report, and it's on the basis of that report that they get credit for those 6 months of study. So for students who have missed submitting one of those reports since the start of pandemic, or had a report rejected because it was submitted late, the policy just gives them 60 days from the enactment of the policy to submit up to 2 of those missed or late reports. They would still have to have met all of the other requirements for the study. So the 6 months of study still have to have been completed. It's just that you were late in submitting that report. So finally, I also want to note that in addition to these more substantive kinds of changes, the rules revisions make numerous clarifying and technical changes just to make sure that the requirements for applying to and participating in both the PTLS and the LOS program are clear to applicants, and also to make sure that staff have clear and consistent rules to follow as they administer these programs. And with that, I just want to end by thanking David and Larry for all their work on this. And I gather that David has already left, but I'll open it up for if Larry has anything to add about the development of the rules package and what's in it. And then, of course, I'm happy to answer any questions.
She did a great job. Thank you. And I have nothing to add.
I'm only going to add, this is a great program. I got to try a case when I was a law student, and I thought it was great for me, and I encourage it for everybody. So I'll make the motion unless somebody else wants to make it. You want to put it up there?
Again, let's check for public comment. Dean Park? No. Anyone on Zoom?
We have no members of the public on Zoom wishing to make a public
No
comment.
members of the public at all?
No, wishing to make a public comment.
No raised hands, okay.
Yes.
All right. Can we put the appropriate motion on the screen? You're showing motions, right? Is that Audrey?
Audrey?
This PTLS motion?
Yes.
Yes.
I don't have that one, but I'm sure I can pull it up from the agenda item.
I can read it if you want.
No, I'm sure I can get the agenda item up.
Yeah, no, I'm not on Zoom, or I try to share it.
I apologize. I also do not have it up because I didn't realize that I would need to share it, but I also can pull it up. Thank you, Audrey.
Of course.
If that motion is on the screen, both motions there. Both moving points.
Okay, so I guess the grace policy would take effect immediately, and rules would go out for public comment. So did we have a motion in a second?
I moved. Anybody want a
Second.
second?
Okay. Roll call?
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan? Jim Epstein?
Yes.
Kareem Bingora?
Yes.
Dolores Heisinger?
Yes.
Judge Herman?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence? Esther Lynn? Bethany Peak? Vince Reyes?
Yes.
David Torres? And Dr. Wilcoxon. The motion passes.
Okay. We are skipping the operations and management goals. And let's see, we have one remaining item in educational standards. That is 0400, action on the amendment to unaccredited guideline 1.11, examination preparation classes as part of the JD program. We've seen this before. Our original rules prohibited law school credit for bar preparation courses. Back in 2009, we issued a temporary waiver that allowed schools to give credit for bar prep courses. And earlier this year, we asked the CS bars to advise us whether the waiver should be made permanent, and if they thought it should, to propose revisions to guideline 1.11 to accomplish that. They've returned to us with a recommendation that we keep the allowance of credit and with proposed language, which is in the staff report. We did slightly tweak the proposal at our CS Bars meeting on Wednesday. But the changes were, they didn't change the main themes. The schools would prefer that we place no limitation on the number of credits that can be given for bar prep. But they also recognize that the committee might want to impose a limitation. And so they provide optional language, which if you look at the proposed language, and you should look at the most recently posted version of the staff analysis for the latest language. So they, at the end of one of the paragraphs, there's a sentence that's in brackets, which is what they would propose if we want to impose a limitation on the number of credits. Staff does recommend that we approve the guidelines, and they also recommend that we include the language that does limit the amount of credits. It's to 15%. of the number of credits that are required to obtain your JD degree. There are some clarifying modifications to the rules regarding the disclosure of financial interests that a school or its instructors or staff or administrators might have in a program, a bar prep program that they're recommending to their students. The idea being that students should know that if they have a financial interest in what's being recommended, that they maybe should consider that in evaluating the recommendation. It may not be completely without bias in that such a case. We also made it clear that if a school is providing the a prep course with its own resources, then it's not subject to the financial disclosure requirement because it's a school program. It's not that they're referring the students out to an external provider. And I'll have one technical suggestion about the motion when we get to that, but it's just a clarification. Is Dean Frickberg with us, or is?
Yes, Deb, could you recognize Dean Frickberg?
So Dean J. Frickberg, who is the outgoing chair of CS BARS, is here to provide its perspective and answer any questions that we have. Dean Frickberg, are you there?
I believe I was promoted, yes.
We're hearing you, go ahead.
Good afternoon, everyone. Just to give a short comment, because I know it's been a long day for everyone on this one. It's been a 13-year process and evolution of this. Again, it goes back to 2009 for the original waiver with an absolute forbidding prior of having this type of review, which I think is definitely necessary due to the unique licensure exam that is the California bar. It was a 7-month process within CS BARS, probably the most lengthy one I have seen in my 3 years when I served on the CS BARS. So I think it's an excellent document, but I would, as Chair Kramer pointed out, the asterisk at the end of attachment B. Again, it was the CS BARS unanimous vote not to include a limit of credit. I was asked to make sure to underscore that for everyone, as again, this would be more of an issue of academic freedom for each institution. And we already have additional unaccredited guidelines on point for what is the quantitative and qualitative requirements of the program. That is it for me. Thank you.
Okay, I'll just say that when you say it was a unanimous vote, I was one of those people voting, and although I voted for it, I think it was also pretty clear that I was in favor of the imposing the limitation. Kind of beat you guys up about that. Would you agree?
I believe there was a back and forth. I don't know if there was a clear victor, but I agree.
All right, so you didn't have to go to seek medical attention. Okay, but anyway, to be clear, yes, I recommend that we impose the restriction. Otherwise, we have created a slippery slope where, in my opinion, law schools could simply become bar exam prep courses, and that's not a world I want to live.
So
anything else, Dean?
No, that is it for me. Thank you.
First, let's ask if there's any public comment. Dean Park will recognize you. She's in the room here, and while she's coming up, Devin, if you can check Zoom, see if anyone has raised their hands.
No one on Zoom.
Okay, thanks.
Thank you so much for the committee's time.
And please project your voice.
Okay, that's what I was about to ask next, because the mic's not here. So should I speak to that? Sure. Okay, great.
Talk to the ceiling.
Talk to the ceiling. Project. I will. Thank you for the committee's time. Similar to Dean Frickberg, I will keep my comment short, knowing that you have had a long day. I just wanted to weigh in about the work.
Who are you?
Oh, sorry. Dean Jessica Park from Abraham Lincoln University. I'm a member of CS BARS that worked on this guideline proposal. So just a quick statement about the people that worked with me. So Michael Clancy, Linda Keller, Paul Kramer, George Leal, Greg Murphy, Jessica Park. That's the roster for CS BARS. a group of the deans from accredited and accredited law schools, as well as our committee members, and as well as Greg Murphy, who is a nationally recognized expert regarding bar examination and former chair of the National Conference of Bar Examiners, who weighed in. Just to give a little bit more clarity to some of what the law school deans spoke about during the guideline, especially about not recommending that maximum limit. A comment that came up a lot among the deans was just about curricular requirements and how the guidelines really and the rest beyond 1.11 would really cover curriculum. None of the law school deans saw that danger. It really hasn't even occurred as an example where a law school is just making all of its curriculum towards bar exam prep. And for ALU, for example, we've never had it as a required credit simply because since 2009, it's been a question really, even if a law school in the unaccredited law school category did this, you know, what is it based on? Is it something in writing? Is it clearly in the rules and guidelines? So I just am strongly in support of getting this in writing. I want to make sure in terms of the perspective of CSBARs, when the law school deans weighed in, the subcommittees that worked on this really looked at what else is being done with accreditors, what else is being done with the law schools generally. That maximum limit we recommended, it came out of a pretty brief look at 7 law schools, at least from my subcommittee side, just to see what kind of programs they had for credit and would this be disturbing any law school in that area. I believe it was 4 CD accredited law schools and 3 unaccredited law schools. But in general, the group was comfortable with suggesting a limit, but especially if this unaccredited law school guideline becomes the basis of what you require for other law schools and other categories. It's just to reemphasize, there's not usually that kind of limit coming from accreditors. They usually see the rest of their guidelines as a cornerstone of what happens with curriculum. And as you know, the rest of the guidelines for the unaccredited and accredited law schools here certainly cover a lot, especially towards that competency training. And there hasn't been an example of that risk that Paul Kramer mentioned. That being said, it was a back and forth, and we're happy. I think we're very proud.
I'm sorry, but your time is up.
Oh, okay. We're happy to present what we had. So thank you.
Thank you. No other comments? We'll close public comment. Any questions, discussion?
I like the 15%.
So,
Oh, sorry to interrupt. We do have a raised hand from George Leal.
Oh, okay. Dean Leal is on Zoom.
Thank you, Chair, and good afternoon, ladies and gentlemen of the committee. I know it's late and I know everyone's tired. I've been listening to the entire meeting today. I just want to really just thank both Chair Kramer and the other members of the CSBARs. This was an intense, lengthy, but very meaningful exercise in the what school deans and what each of us bring to CSBARs in terms of offering, a deep understanding of how this rule change will help each of our programs. And I would strongly urge the committee to vote in support. This is long overdue, as you can tell, and it provides very explicit clarity in terms of what schools are able to do and how they should offer or may offer their students these very valuable programs. And the last point is for many of the members who are not as familiar with our schools, particularly the registered schools, these programs can be and often are the key to success for our students. And when our students succeed, our school succeeds, particularly in my school's case, I'm sorry, the Dean of Irvine College of Law, I should have said that to begin with, in our long-term quest to become accredited and getting our students to pass the bar exam with the assistance of a bar prep review program that we now have will hopefully be the key to our future success in becoming an accredited school, as other former registered schools that have now
30
become
seconds.
accredited With that, thank again for your time and attention, and I appreciate your considered vote and approval of the proposed amendment.
Thank you. So we have the proposed motion on.
Well, Paul, I'm sorry, I'm a little out of it on this. So I'm used to you graduate from law school and then you start your bar prep and then you take the bar. So this puts the bar prep before you even graduated from law school.
And also an element of it can be first year law students exam bar prep too.
Well, just the part about the bar exam. So this is, even though you have not yet graduated from law school, you would be paying your school for bar preparation.
They offer it in different ways. Some just include it as a part of the curriculum and it's, it's paid for by the tuition. I guess some refer to, refer you to an outside course. I came from the same place you did that.
What is it that you like about this idea for the bar exam, not for the baby bar, but what's the upside to this?
Helps the schools prepare their students for the bar. No, I'll admit I come from the place you are, where my desire to put a limit on it was because I have the old notion of law school that it's to give you a wide range in education and the areas of the law and socialize you and things like thinking like a lawyer and all that, and anything that takes away from that, isn't a good thing. But